mention an admiralty suit, my lords, which is being filed, my lords, against a foreign vessel. We are seeking, my lords, moving for arrest, my lords, under the Admiralty Act. My lords, the suit is getting lodged, my lords. If the court could, my lords, assign, but this matter will have to be formally assigned. I'm told in the list, my lords, there is no Admiralty assigned. Roster does not have, my lords, an Admiralty register.
For the first time that a case of this jurisdiction is being mentioned, rather discussed before me, brother.
Yeah, my Lord Justice Orindam Sinha, my lord, is a.
Please,
my lords, I'm grateful. But there is a diary number we've got. We are getting it, my lords. My lords, the advocate on record is, my lords, doing its best. I am extremely open. But can it be taken up today itself? It's a foreign vessel.
It's very difficult.
But the difficulty is, my lords, in this jurisdiction.
Because your suit has not been registered even.
It will be registered. I'm told it will be registered by 2 p.m.
Then make a mention in the second half. Take back the slip.
I'll mention. I'll trouble
the diary number, my lords. Once you get the number, my lords, you'll make a mention.
We'll mention it.
Subject to my lord's permission.
I will trouble the court at 2 p.m. I'm extremely obliged.
So, submission item number 1. May it please your lordship. My lord, this is a case, my lord, a school run by an educational trust praying for a direction to the revenue authority to consider the application under the Odisha Government Land Settlement Act, my lords. Under the Rule 5.2, we have filed an application on Form IA for the settlement of a portion of land in favor of the trust so that it can run the school, my lords. In the last occasion, your lordship has directed my learned senior to take instruction whether it can be settled. And second, my lord, the specific question was put that whether government has any scheme to consider which purpose will be considered first, which will be considered next. So that was the purpose for which your lordship was directed.
When was that order passed?
My lord, sir.
Its order was passed on 17/12/2021.
Yes. So have you received instruction?
Because I have received instruction so far as status of the land is concerned. The land for which he has applied, my lords, it's a river, my lords. So objection land cannot be settled with them, my lords. But so far as that, my lords, scheme is concerned, my lords, even though I had, my lords, written to them as back in 21.
If it cannot be settled,
No.
then there is no question of
Obviously
going
not.
into the scheme.
Yes, sir. But all I pray, now I have heard this, that it cannot be settled. May I take the liberty of your lordship? I'll make a fresh application that may be considered in merit.
Why? If the land is a river.
No, a fresh application with other land in the same area.
That's all right.
But the reason is because the CBSE requires 2 acres of land.
Council appearing on behalf of. Because it's a river. It is impossible. Pursuant to this court's earlier order, Learned State Council has informed this court that he has received instructions in respect of the land which the petitioner wants to be settled in its favor. Under which provision? Which act?
That's Rule 5.2 of Rule 2 of Odisha Government Land Settlement Rules.
That's
Rule 5.2,
Rule 5, Sub-Rule 2.
Sub-Rule 2.
Yes, nurse.
Rule 5, Sub-Rule 2 of Odisha Government Land Settlement Rules, 1983. Land, the said land is a river bed or what?
Yes, that's a river bed, nurse.
Is a river bed, and therefore it cannot be settled. So, Learned Counsel appearing on behalf of the petitioner in response to the said submission made on behalf of the estate, has submitted that he may be permitted to withdraw the writ
Right.
application with a liberty to make press application before the competent authority for settlement of an alternative
yes.
land.
I'm okay. Item number 2.
May I please, your lordship? Like this is a second time litigation challenging the rejection order under Annexure 6, my lord.
Yes,
The regarding the land in the schedule of the government land, my lord, they encroach since forefather of the petitioners, my lord.
what
Till then,
happened? Please come again.
my lord,
What happened?
my lord, to settle
Please
the
make your submissions again. I just missed.
to settle the land under Annexure 6, my lord, rejection of my repentation second time litigation, my lord. Under Annexure 6,
So you want some land to be settled in your favor.
my lord.
Under which provision?
OGL acts, my lord.
OGLS Act. Please.
Then what is wrong with the order? What right do you have?
My lord, I have possessing since 1960 years, my lords. Forefather young lad, the land is converted to government land, my lord.
Let us see where.
Landless person, my lord.
Yes, this is what, there is no provision for settlement of the land, encroached land.
My lord,
Then what is wrong in it?
being a long person,
Mr. The principle is very clear.
my lord, my lord.
Unless you demonstrate before the court that you have a legal rights,
My
the
lord.
court will not issue any direction. So you will have to convince the court that this is your right which has been violated by the order or action or whatever.
One chapter I will
You will assess.
urgent.
All right. As requested on behalf of the petitioner, you effectively assess this to effectively assess this court, this matter on 1 week.
My lord.
Item number 3.
May I please, your lordships? Lordship, while order dated 29/9/2022, I was directed to file the consolidated petition. I have filed it, your lordship. But on that day, nobody was appearing for OP number 2 and 3. Now my learned senior is appearing for OP number 2 and 3. I may be permitted to serve them a copy.
About what?
It's about, your lordship, the matter is about the non-release of the admitted dues of the petitioner, your lordship. The petitioner executed a work for the OP number 2 and 3, that is NBCC India Private Limited. Now NBCC India Private Limited is not releasing my payment, stating that the OP number 1, that is CCL. CCL has not given them the payment. The dues are admitted. When I'm approaching NBCC, they are saying that we will pay you, but it has to be cleared by CCL first. So that is the matter, your lordship. If I may be allowed to place the,
I will file a counter, my lord, probably let them solve a copy of the consolidation.
If the dues is admitted and you are not paying, then it's a very serious matter. This is no dispute. This is admitted. The amount is admitted. According to you, he is entitled for payment. But you are not paying because CCL is not releasing. CCL had not given him work.
Yes,
The work was given by you.
yes, sir.
And you are saying that you are waiting for a fund from the CCL.
So that is the reason I'll take it.
So there is no dispute in it. If everything is admitted, then
The admitted dues, I don't think, but.
your lordship, may kindly come to page 74.
no,
Yes.
I'll give you time to file counter
Yes.
affidavit. But we are making it very clear
Yes.
that this is a very serious matter when you are delaying payment of the amount which is admitted. In respect of it, there is no dispute
Yes,
as
Copy.
requested. You are representing NBCC,
Yes, my lord.
opposite
No,
party
2 or
number
3.
2 and 3.
I am appearing for CCL.
Why have you made him partner?
Because
They have
PCL
made
is
him
not
a
releasing
party.
the dues, your lordship. That's
Why do your contract was with the MBCC? Unnecessarily you have.
I have also raised a grievance with them, your lordship, as well.
No, you can't have any grievance against him. You may have a grievance against your the person.
Yes, lordship, but
All right. Learned counsel appearing on behalf of the petitioner has submitted that a consolidated writ petition has been consolidated.
only the certificate part was missing, your lordship. The certificate has been added.
All right.
Consolidated petition has been filed, your lordship.
A consolidated petition has been filed. A copy of which shall be served on learned counsel for the NBCC. Bracketed, sorry, you are there. I am. He should sit there. Whatever it is.
Council appealing petition has submitted that the consolidated writ petition has been filed. A copy of which shall be served on the council.
Requisite number of copies of which shall be served upon London Council for the NBCC bracketed opposite party's number bracket closed in course of the day. Stop. List the space on 4 weeks. Stop. 4 weeks so as to enable London Council for opposite parties number 2 and 3 to seek instructions and file counter affidavit. Stop. A submission has been advanced on behalf of the petitioner that the amount which is admittedly payable to the petitioner is not being paid by the NBCC on the plea that CCL is not what is CCL?
Central Coalfields Limited.
Coalfields Limited is not releasing fund. Stop. There is no dispute that the agreement was between the contractual agreement was between the petitioner and NBCC bracketed opposite parties number 2 and 3. Stop. The court expects that the opposite parties shall make the endeavor to ensure that admitted dues is admitted amount is paid to the petitioner in the meanwhile. Do it.
Item
If there is
4.
any dispute, we will not enter into that.
Yes.
But if there is no dispute, then this litigation is unnecessary.
Obliged, your lordship.
Item number 4. Item number 4.
Yes.
My lord, I seek your adjournment of 1 week, your lordship.
Why, sir?
My lord, because my lord, the London senior Mr. K.P. Mishra has to argue the matter. Actually, he is not well today. He instructed me to seek one adjournment.
On the ground of indisposition of London Senior Counsel, a short adjournment is being matter on 1 week.
My lord,
Item 5.
deeply obliged.
May I please your lordships? My lord, this is the WPC in the form of PIL for preserving the interest of the villagers of Jangada, who are the tribal inhabitant of the village, owing their long residence and shops adjacent to the plots which has been allotted to BPCL, my lord, in lease. My lord, BPCL has leased the property for a mother station of gas filling, my lord. Earlier, the petitioners approached this honorable court in WPC PL number 21609, my lord, of 2022 for redressal of their grievances, and this honorable court has directed the immediate authority, that is the OP number 3, my lord,
Who is
to
OP number 3?
that is the collector of Sambalpur, my lord,
Yes.
as he is the immediate authority to take action, subject to the condition that he will listen both the petitioner and the opposite party number 3, that is BPCL, and after that he will pass a reasoned order, my lord. And accordingly, the OP number 3 called the petitioners and the OP number 5 also, but without going to the grievances, he didn't listen to them and pass the order rejecting the same representation, my lord, which is in Annexure 7, my lord. My lord, according to the gas cylinder rule 2016, my lord, section 48, subsection 3, subclass B, my lord, it clearly says that no objection certificate must be obtained from the concerned Gram Panchayat, my lord.
Please wait for a while.
Yes, my lord.
Who are you?
I am the petitioner, my lord.
No. Who is the petitioner?
My lord, I am a villager, my lord.
You are a villager.
Yes, my lord.
Yes. Can you tell us where this station should be
Yes, my lord. The villagers,
located?
my lord, the villagers have no objection if it will be located 1 kilometer away from their vicinity.
All the villagers of all the villages in the state of Odisha would be raising similar objection.
Absolutely, my lord. But here, if it will be adjacent to their shops, then it will affect their bread and butter, my lord. So if it will be done in 1 kilometer away, they have no objection, and it will safeguard the locality also. They apprehend
What
that
is the stage? This writ petition was filed in 2023.
3 minutes.
So what is the stage? Whether it has an
No, Lordship have not been, because he was advised to file the second copy of the writ petition, which was not filed by
Yes,
the
ma'am.
order dated 7/7/2023. Lordship have not yet issued notice or any such for instructions.
It has already been
2022, he had raised this objection. I think that as per their amendment, possession was handed over and they started construction. What is the stage at present, I cannot, because
tell us.
My lord, they have constructed the boundaries as per the instruction received, my lord. And we have filed an IA number 4546 by 2023 in light of that, my lord.
and it is a gas storage plant which shall be beneath the ground, and it will supply to different stations for the consumption by the villager. That is the, and then they were given.
What is the system? Copy is Copy of the writ petition has been served on you.
Yeah, one advance copy has been given to me, my lords.
Then you need further copies.
If your lordship please to issue notice, then they give sufficient number of copies as per this notes, opposite parties.
As per what?
For obtaining
I am trying to understand the procedure. To notice. AGA, you are AGA?
Yes. Additional government advocate.
When an AGA receives notice. Stop. Accepts notice. Stop. This matter on 6 weeks.
Yes.
Let a counter affidavit be filed in the meanwhile.
Lords, may I pray one thing? For 1 to 4, I will enter appearance, lords. So far 5 is concerned, it is the beneficiary company under the government of India, lords. So notice has to go by restored post to them, lords.
All right. Okay. Opposite party number?
5, lords.
Opposite
Five.
party. Second, because or opposite party number 1 to 4.
Yes.
Yes. How much time will you take? For the requisites? 2 weeks. Preemptive.
Yes, my lord.
Item number 6.
God bless you.
Item 6, permitted to withdraw, my lord.
Non-counsel.
We are for the opposite party.
Krishna 6 permission to withdraw this application or memo level.
Sorry.
Yes.
Item number 7.
May I please your lordship? My lord, this is a case. In this case, the petitioner is the lessee of the land who has obtained the ROR by the Tahsildar opposite party number 4 prior to 33 years. After 33 years, the lesser opposite party number 4 Tahsildar who has sanctioned the lease, he has filed the appeal before the appellate authority, the sub-collector, under section 7.3, sorry, appeal 7.1, which is not maintainable. After 33 years, my lord, the appeal period is 30 days. And instead of 30 days, after 33 years, the lesser, he has filed the appeal.
So you are challenging filing of the appeal.
My lord, and without a limitation period, without limitation petition. So
You are challenging filing of the appeal or any order passed by the appellate authority.
appellate authority allowed the delay without, and I have filed the objection. And in his order, he mentioned that as a collector, concerned collector has directed to file appeal to the Tahsildar. So Tahsildar has filed appeal, so the limitation petition is not necessary here. In this ground, he has condoned the delay 33 years.
Which connection?
Yes, may consult the litigation, may I pray, lordship may kindly look at the order dated 4th July 2023. First, their lordships were free to direct the petitioner to file the lease deed, my lords.
My lord,
He has filed the lease deed.
My lord, in the last occasion, Honorable Court has ordered to file the lease deed. But the petitioner applied before the concerned authority, and I have filed the affidavit, and Tahsildar has denied that a lease affidavit is not necessary, and a lease deed is not available. Before 33 years, it is, my lord, this is a cultivated land. So lease.
Counsel, you are relying on a lease deed.
No, my lord. No, my lord. I relied upon the ROR which has been issued by the opposite party.
ROR?
the
All right, record of rights.
record of right has been issued by the opposite party number 4, the lessor. The lessor who has allowed the lease land in my favor. And the appellate authority is the confirming authority. After passing this order has been communicated to the appellate authority sub-collector. And after his confirmation, I have obtained the ROR. That is in statute right. And I am paying rent regularly. Till date, I am paying and I am in possession. And but the limitation has been condoned as per the direction of the collector.
Let us see the order. Which annexure?
It is
Which annexure is the order condoning delay? Annexure 4.
Copy of the annexure. My lord, annexure 4. Annexure 4, page 28. Wait. My lord, page 20. May I read? Page 29.
Please.
Hard learned government pleader for the appellant and Mr. S.C. Samal, the learned advocate for the respondent. Gone through the objection filed by the respondent, learned advocate for the respondent objected about to non-filing of limitation petition by the appellant to condone the delay of a period of about 35 years for which this appeal requires to be dismissed. In the instant case, the Honorable High Court of Orissa, Cuttack, in WPC number 14636 of 2014, violated their order dated 5th November 2015, directed the collector Cuttack to dispose of the representation of the petitioners within a period of 3 months, and the Honorable Collector, in its order dated 9th December 2015, ordered the Tahsildar Tangi Chaudhar to file appeal and also instructed the sub-collector to dispose the same in compliance to the order of the Honorable Court. Therefore, the issue of limitation does not arise. Ask Tahsildar Tangi Chaudhar to submit the entire case record of lease case number 85 by 1986 in original to the court without delay. Respondent is instructed to file copy of concerned lease deed by the next date positively. My lord, lease deed at that time, the prevailing lease deed system was not prevailing because it is a cultivated land. It is not a homestead land, it is a rural area. So lease deed has not been executed. So it is not possible to file the lease deed. Then second thing, 33 years, after 33 years, the lessor has filed the appeal. Lessor has filed who has no locus standi to file, who has sanctioned the lease. He has, after 33 years, he has filed on the basing on the order of the collector.
Where is the memo of appeal? Where is the memo of appeal which he has filed?
My lord, in annexure, page 11, annex. Page 11, annexure 2 series.
This appeal has been preferred under which provision of law?
7. My lord,
Just a minute, sir, please. 42, no? 22. You have filed this appeal against which order?
There's no order. There's, as per the direction of the Supreme Court,
I got it out.
that he has not filed. Not.
Why should he file? You are challenging an order.
No, right.
Where is that order?
Yes. Or it's not an order because he applied for lease of land. A lease case was this case was
No, that is not the. Let us come to the appellate provision.
Yes,
Come to section
7. 7.1
7.1.
Yes, 7.1a.
Yes.
Where the order is made by the officer below the rank of subordinate officer, then it will be to the subordinate officer.
Here is a situation where you are challenging an order. And you are asking him to produce the order, which you have challenged.
No, I am not asking him to produce it.
No. You are relying on an order passed by this court, whereby he was required to file.
No, but he has never been required to file notes because the collector had directed the Tahsildar to produce the records notes, not him. Because you'll also see this appeal was filed by the Tahsildar saying that the lease which was granted was in violation of the rules because there were no proclamation, no other things, not general notice, notes was never issued. And delay was condoned. And by condoning the delay, the sub-collector has asked the Tahsildar to produce the lease records, so also all the orders, not to the present petitioner.
My lord, to produce the lease deed, the sub-collector has ordered to produce the lease deed to the petitioner.
Where is that?
Right.
On please.
My lord, may I read it? The last part of the order. Clearly, the Tahsildar Tangi Chaudhar to submit the entire case record of lease case number 85 by 1986 in original to this court without delay. Respondent is instructed to file a copy of concerned lease deed, my lord, which has not been executed. Lease deed has not been executed prior to 33 years because it is a cultivated land and it is a rural area. No deed has been executed. And thus,
Third party is also in this case.
No, my lord.
No, but this order was passed by the High Court at the instance of some persons who had approached this court.
My lord, may I be pardoned? Honorable court has not passed anything over the matter, over the facts. Only the Tahsildar took dilly-dallying process to dispose the representation by the villagers, and the only direction is to collector to dispose the matter, to dispose the representation. My lord, except this, court has not directed anything to the collector. Only direction has been given to the collector to dispose the representation, nothing else. This is the order of the Honorable High Court. It is the High Court.
The petitioner has put to challenge an order dated 18/4/2023.
My lord, page 26.
Passed by the sub-collector Sadar Katak in which proceeding? And miscellaneous bracketed A 8/2018 on an appeal preferred by the Tahsildar Tangi. What is
Tangi Chaudhar, TNGA, Tangi.
Tahsildar, Tangi Chaudhar. जो भी चार द्वार whereby after having opined that there was no question of limitation in preferring the appeal, the Tahsildar has been asked to submit entire case records of these case number 85/1986 and the petitioner has been asked to file a copy of the concerned lease deed. Assailing the impugned order passed by the sub-collector, learned counsel for the petitioner has argued that the entire proceeding before the appellate court, before the appellate court of sub-collector Sadar is that the submits that the appeal preferred by Tahsildar before the appellate court is not maintainable under section 7(2). Under 7(1)
and A, Milords.
Under 7 of the Odisha Government Land Settlement Act 1962. First off, he contains that the appellate court has wrongly noted that no question of limitation arose, completely ignoring the fact that the lease deed in favor of that the land in question was leased out to the petitioner nearly more than 35 years,
My lord.
35 years ago. And therefore, the appellate authority was under obligation to address the issue of limitation. Stop. Next. He has also pointed out that the direction by the appellate, by the sub-collector, requiring the petitioner to submit lease deed
My lord.
is wholly unwarranted, inasmuch as no such lease deed was executed and there was no such practice at the relevant point of time. This is what he submits.
He submits notes, right?
Oh, stop. Next. Issue notice. You have received a copy?
One advance copy, you also direct one more copy to be given to me so that I can obtain instruction in the matter.
Learned AGA accepts notice on behalf of the opposite parties and waives the requirement of issuance of formal notice. Stop. Let a requisite number of copies of the writ petition be served on learned AGA in course of the day. List this matter on 6 weeks. Oh, stop.
My lord, may I pray? I have filed the IA to have a stay of the proceeding.
No.
My lord, otherwise the proceeding will go on.
Proceeding will, we are there. We are there. This order was passed in 2018 for 2023. We are in 2024.
My lord, that is the only, this is the order of IA, the limitation petition. This is the order of only over limitation petition. But the case is pending and it is going on.
All right. Let it go. Let it continue. We don't know. We have not decided. We are not prima facie satisfied that the entire thing is, we have just noted your submissions and we will decide your matter finally.
My lord,
Tell us. List this matter on 8 weeks. Stop. Let counter affidavit be filed on behalf of the concerned respondents by the next date. Stop. It goes without saying that in order passed by the sub-registrar in sub-collector in miscellaneous appeal, miscellaneous case bracketed A8 of 2016 or what? 16 shall be subject to final result of this case.
2018.
2018 shall be subject to final result of this. Yes.
Item number 8.
Yes, please.
By order dated 21/7, this honorable was pleased to issue notice to the opposite party.
Yes, we are forgetting that thing, Mr.
And a batch of case has been filed. A batch of case has been filed.
Mr. Counsel who was appearing in the previous case. Can you follow?
State is appearing. State is appearing. State is appearing.
No, we will not. Sorry, I forgot. Most of the cases are not supported duly by affidavit. They'll have to
Curative affidavit you also wanted to file notes.
Yes, affidavit will have to be filed. You file an affidavit. Otherwise, we will not entertain affidavit. So those, you file your affidavit. Otherwise, we will dismiss your petition on that ground alone.
Supplementary affidavit, case for rules.
Any matter, every matter, every case. In every case. Sorry, we forgot. उसको ये delete करो order. 2 weeks time is. I don't know whether for the petitioner is permitted to file.
My lord, may I be permitted? I took 1 week because I will intimate the client for affidavit.
We are giving you time. The difficulty is that we cannot entertain any writ petition which has been filed in contravention of the rules, High Court rules.
My lord.
That is the whole difficulty.
My lord, I pray for time.
We are giving you time. Why are you worried? We are not against anyone.
My lord.
We are for the law and the rules.
My lord. My lord.
And
Obliged.
Current counsel for the petitioner is permitted to file a supplementary affidavit in support of the averments made in the writ petition in accordance with the requirement made under Rule 3 of Chapter 6 under Part 2 of the rules of the High Court of Orissa, 1948. Let it be done by
1 week time. I pray
1
for
week.
after 1 week.
करके वो फाइल में रख दो जो ऑर्डर लिखवाया करने ना उसको रख दो सो दैट आई मे रिकलेक्ट
Item 8.
In item 8, by order dated 21/7/23, notice has already been issued and a batch of case has been filed on similar issues, and the government has filed in one case their counter, which has been adopted by them in all other cases. And
all right, we'll do that.
yes, but
Let's
your lordship has directed to list the matter along with that case, but till that this case has not been listed. I pray let this matter along with others be listed tomorrow. Yesterday.
No, whether other matters have been listed.
No, my lord, earlier listed, and your lordship has passed the order. I have given that order.
No, whether these matters have been listed, 9791.
Yes, my lord. On 27/9, it has been listed. Thereafter, it has not been listed. So I pray, let the matter be listed
Yes.
along with this. Next,
Stated by learned counsel for the petitioner that the issue which the present writ application involves is involved in a batch of analogous matters. Leading case being WP bracketed C number 9791 of 2023 bracketed Srikant Mishra and others versus the state of Odisha and others. First off, list this case along with in view of the submission advanced on behalf of the petitioner, this case, along with WPC number 9791 of 2023 and other analogous matters. First off, the court makes it clear that the petitioner shall be required to file an affidavit in accordance with provisions in support of the averments made in the writ petition, in which the writ petition may be dismissed on that ground alone.
A date may be fixed, my lord.
We don't know what is the date fixed in that case. You want your matter to be listed along with that. We don't know what is the date fixed. So if you tell us, if you can tell us what is the date fixed in that, we date fixed as well.
That was date was fixed for 22nd September 23, my lord.
So that date we cannot do.
Yes, my lord. Thereafter, matter has not been listed. So if a week after or next week, any date, my lord.
Let it be listed along with those cases.
Unless your lordship is directed, that matter cannot be listed. That is the whole difficulty.
So are you counsel in that case?
Yes, in some of the cases. Yes.
Make a mention.
Right.
Make a mention, we will see.
God bless.
Item 9.
May it please.
Just. Yes.
In the case, the Union has challenged the order of the London Scientific Tribunal.
Yes. Same rule will apply in your case also, sir.
Yes,
Do it. Correct it. If
we'll file within a week, my lord.
ये क्या है?
which is Solicitor General is not a senior counsel. All right.
Under disposal of my lord.
Yes. Just
Two different cases and filed out of the two judgments, my lord. Here is the case, the concern one of TT, ticket inspector, has taken bribe of 400 rupees and 200 rupees.
Then?
In first charge, he has taken 400 as found and he had not issued the receipt. And another case was found subsequently on the allegation of another passenger that he has collected from another berth, my lord. He has given SC coach, taken money without any receipt. But the learned tribunal come to a conclusion that the speaking order has not been passed in the appeal. And I am Lord Lasimesi, I got the document, I could not file in affidavit. Lasimesi, the judgment of 11/5/2003, Lasime come to the crux of the page is page 34.
No, first of all, you correct your affidavit.
Yes, my lord. We will correct the affidavit. Lasime keep it to 1 week after.
Deputy Solicitor General seeks adjournment to file an affidavit supporting the supplementary affidavit supporting the contents of the writ petition in accordance with so and so. Stop as requested this matter on 2 weeks.
Yes, ma'am. Oblige, ma'am.
Item number 10.
My lord, in first case, Mr. Gochayat is filing the same. Second case, Mr. B.K. Pat name may be reflected along with me. Oblige. Yes, I'll give a plus. Yes, ma'am.
Item number 10.
Lord, may I please, Lordship? Lord, two grounds of attack. The basis on which the impugned demand has been calculated and raised, that is the order of the loan and NGT which has been set aside, my lord. That's a subsequent development.
This is WPC
34359. Your Lordship is right. Lord, there is a development. Lord, this is the order. The impugned NGT directed the state government that whether there has been extra excavation of the earth. My lord, I was engaged for widening of the road. That NGT order has been set aside, my lord, on the ground of violation of the principles of natural justice, number one.
Just a. Yes.
My lord, I passed on the order, NGT order. Let this is the, if your lordship put, this is the final order of this honorable court. A honorable single bench was pleased to set aside and remit back. So this calculation has been made on the basis of the impugned order of the NGT dated 26th of August as page 46 your lordship would find, and the inspection 46 my lord, page 46. That has been set aside. So this demand has to go on the basis of that. Page 46 my lord. The NGT directs the director mines, and the director, my lord, may take the measurement in my absence, which is the requirement of Rule 551, Schedule 4 of my lord, Orissa Mineral Concession Rules 2016. Before going to this rule, the basis for calculation is the NGT order. That has already gone. So this demand has to go on that basis. Because, my lord, the whole...
Because of this order?
Because of that order. Because that has already been set aside. So this demand was prepared on the basis of the direction that has been...
No, I have not seen, ma'am.
I'm passing.
First
That's
of all,
the subsequent order of January, my lord.
We will take up the matter tomorrow then.
Lord,
He may agree to that.
Tomorrow.
Tomorrow, ask someone, your junior. We know that.
No, I'll be there. My lord. Tomorrow I'm here. I'll be there.
No, you were on the last date. I remember when you were saying that you will not be available.
No, I know. Justice Sodangi rather my lord told that I may be there.
Sorry.
No, I'm very much here.
Go through the order, and if he agrees, then we can dispose it on. Discuss matter tomorrow. It can be listed tomorrow, no problem.
Obliged.
So as to enable and state council to consider the order which has been passed in so and so. Over there, single judge. No, so and so. Okay. So dated first, so and so. In relation to the issue involved in the present matter. Yes.
Item 11.
Obliged.
May I please, Lordship? In item 11, on request of Mr. Akshay Kumar Pandey, Your Lordship, I seek for an adjournment. His son is not well. He has been hospitalized. Lordship, may kindly grant me 10 days time.
As requested on behalf of the petitioner, list this matter on 2 weeks. 2 weeks, madam?
Yes, Lordship. A date may be given if possible.
2 weeks date will be there.
Much obliged.
No adjournment without date.
Much obliged.
Item number 12.
May I please, your lordship? My lord, the petitioner is a lessee. lease around land of 1 acre has been settled in his favor. The learned collector waived the salami when the lease was granted because of his poorness. And accordingly, Jamabandi register was issued to him under Annexure 1, capital A, that is page number 13. Subsequently, while he was in peaceful possession of the same, the learned ADM initiated a suo motu proceeding under Section 7, capital A of the OJLS Act. And in that case, saying that the settlement is illegal, contrary to the law. Therefore, he remanded the matter to the Tahsildar again, directing him to fix the settlement of the land to the extent of an area acre 0.040 decimals. And after remand, the Tahsildar entirely taken out the land, saying that the petitioner is not in possession of the land, that your lordships can find.
Master, again, file your affidavit first.
Yes, my lord.
2 weeks. Why is this practice?
My lords, it will cause lot of problems, my lords. Around 15-20,000 cases will come under this.
The whole, Mr. Counsel, the whole difficulty is, speaking for myself, it will be impossible for me to adjudicate writ petitions based on such kind of affidavit. Because there is no evidence taken in the writ proceeding.
My lords, what I submit, my lord, was never insisted. That is why nobody filed in that form.
Therefore,
But we can do it. Today we can do it.
You should do it, one. And two, we are giving you this. This is nothing. See, when you make a statement in your writ petition.
My lords, I understand. This is
you understand this.
Prevailing everywhere.
You understand this. Now, if we start deciding, allowing or dismissing writ petitions, then it can be said that where from had he got this information, and the High Court has decided on the basis of nothing.
My lords, what?
So therefore, what? Why I am insisting that in order to effectively decide the case, we will be very liberal in granting you time, but that formality will have to be done.
My lords, henceforth we will do that in that form.
You do it.
But for the cases already filed,
no, we are not.
We
will not dismiss. We will give you time. You have to just file a 2 pages affidavit that this statement is based on your information derived from record, your personal knowledge, or information derived from so and so, your legal submissions. So this is how the affidavits are to be there. So rest assured that this will not be an impediment. This will not delay disposal of cases. But I shall ensure it. Not only even in the absence of those rules, I would have insisted upon, because that is how the writ petitions can be decided. Otherwise, just saying that I know that the facts are true to my best of my knowledge and belief. So you can if some action is taken against the deponent, that how could you make this false statement? Yes, I was under this belief. It was not within my knowledge, but this was my belief. So therefore, and I assure all the members of the bar that I'll give you time. I'll expedite the hearing of such matters. In no case your hearing can be delayed because of this. All right. This I assure all the members of the bar. And if any what happened, senior counsel was appearing. He appeared on last Friday. The matter according to him was urgent. We fixed it today. He filed the affidavit on Friday itself. All right. So this is simple exercise, but this will improve the situation a lot. And this is necessary also for the young members of the bar. Otherwise, they are also developing this. I don't think senior counsel is there. He's young, Mr. Senior Counsel. You must be remembering how the affidavits were filed.
This format was brought in, but then for some time it was
kept in on the request of the bar.
Just a minute. I was
No, I
informed.
don't want to join issues on.
No, you should. I would invite the members of the bar. I would invite the senior counsel also, everyone. It is not that I am perfect or this bench is perfect and all the members of the bar are incorrect. The question is that whether we can keep statutory rules in abeyance. Can we? And even in the absence of the rules. So therefore, and I would invite members of the bar. I don't have any.
What falls from your lordship, my lord. Here, we will in fact, my friend who was the former secretary of the Bar Association. So we would in fact immediately rectify the fresh filings. That is well taken across the bar. All of us have accepted it. So far as pending matters, as it falls from your lordship, some latitude if it can be extended.
That we ensure, and I don't want to do that. But if a situation arises, I'll have to decide the issue.
We totally get it.
And instead of deciding the issue on the judicial side,
Not required, my lord.
not required.
So far as writ appeals and other matters, I think they can be out of this. Writ appeals, which are appellate, which probably don't require a.
The moment there is statement of fact, if there is statement of fact, if the appeal does not contain any fact, it just takes the grounds. Writ appeals are based on the statements already made in the writ petition. So writ appeals are nothing but the grounds which are taken to question the order. But the moment in writ appeal you make a further statement of fact, then you'll have to say that this fact is based on what.
But in fact,
there is no technical.
You don't require affidavit, my lord. In appeals.
Right. Because you in appeal you don't require affidavit because everything is there already on affidavit. We will see. And just this is an attempt. It's
prospectively applying it, all of us,
yes.
no problem.
Everybody will be happy.
We have already rectified our systems.
No.
But pending matters is something which there is some apprehension.
Again, I am reiterating my again speaking for myself that if this asks yes for the bench, that it will be difficult for me to decide cases.
We totally get it.
Yes, it will be difficult. So the moment you say that this information and writ proceedings, I repeatedly saying is decided on affidavits. Therefore, and I assure you that as the Chief Justice on this is a major issue which has emerged. I can understand the predicament of the members of the bar. And it is not that I have come from somewhere else, right? From the same community, from the same. So I can understand well the difficulties, but I again assure you that I'll cooperate if a hearing of case is to be expedited and it may be it is getting delayed because of this requirement. I'll ensure that something is done, something on case to case basis. All right, please. Yes, sir. Do it first.
My lord, next item 13.
Do it.
13.
I feel very sorry about it.
Item 13 also.
Same.
Item 13.
In case of item 13, my lord, your lordship was pleased to direct the learned state council to take an instruction as to whether the revision case is pending or what is the progress of the revision case? The order of this honorable court has been passed in the year 2012, but the revision case is pending since then, no progress.
My lord, let him rectify this affidavit. I will take the instruction on the next date, positive. I'll file the affidavit.
So I'll allow him to rectify, but
I will.
if what he is saying is incorrect, he is correct, then his
On the
revision
next date, your lordship may grant me 1 week time. I will get the instruction.
all
and
right,
file it.
then we are adjourning the matter for a week.
Yes.
You tell us in the meanwhile, he will do it.
Yes.
But within top 5 cases.
Yes, my lord.
List this matter on 2 weeks. Stop. In the meanwhile, land council representing the estate of Orissa shall be required to inform this court as to whether the revision.
Yes, my lord.
What is the number?
RC number 229 by 1981.
RC number 229 of 1981. Pending before the
ADM Bhubaneswar.
ADM Bhubaneswar has been disposed of or not?
Yes.
List so and so within first 5 cases. Stop. Land counsel for the petitioner undertakes to file a supplementary affidavit in support of the averments in the petition in accordance with so and so in the meanwhile.
Item number 14.
May I please? Here, my lord, the order of this honorable court dated 5/12/2022 has been violated by the contemptor and has declined to implement the award. As
order?
directed, my lord, under Annexure 1, page 10. This honorable court directed
What is the order?
page 10, my lord, we notice the workman had approached the Labour Commissioner by letter dated 9th June 2009. Opposite party number 1 filed the writ petition impugning the award, which were dismissed as far back as on 7th November 2017. In the circumstances, the opposite party number 2 and all concerned are directed to take steps forthwith for implementation of the award in accordance with the law, my lord. Thereafter, my lord, the opposite party number 2 directed the opposite party number 1, the contemptor, to implement the award, Annexure 2, page 12, my lord. But instead of implementing the award, he has declined to implement the award, stated that the scheme is closed and the employees, those who are working, they were engaged in different offices, my lord. Instead of implementing the award, he has said that the award cannot be implemented. He ought to have placed him in different, as he has done in case of others. My lord, he has also annexed that, page 17. He has deployed them in different organization as per the scheme. But in the case of the petitioner, he has said that I will not implement. My lord, my friend is appearing.
Instruction in the matter.
My friend is appearing for the contemptor, my lord.
You had 2 options. You could have filed a review
Obviously, my lords. No,
You did not do that.
so far it comes to the state government, my lords. Where I am concerned, my lords, the commissioner is directed to implement the award, my lords. And so far as the contempt of the executing authority, my lords, for which my friend is appearing, he can answer because I had directed implement the award as per letter and spirit.
2 weeks time may be allowed to comply the orders, my lord. That is my instruction.
Yes, my lord. Yes.
My lord, he says, my lord, 2 weeks time to comply the order. If friend says he will implement the award within 2 weeks, my lord.
My lord, let the, my lord and friend, copy.
My lord, but his statement is,
My things.
my lord. My lord, the order, your lordship may kindly see the last order of your lordship, where the lordship has held directed that the implement the award forthwith, my lord, by the all concerned, my lord. My lord, since they are undertaking to implement the award, my lord, the workman, poor workman, my lord, since 2009, he is suffering, my lord. Years together, my lord.
My lord, I am for the opposite part number 2.
No, contender.
Contender.
He is the contender.
Contender, my lord. Get a copy of the staff document. My lord. My my name, Ansura Mishra.
My lord, only one opposite party. Only one opposite party.
I don't mind. Maybe comply within 2 weeks. Comply within 2 weeks, my lord. That is my instruction.
Advertising. State resource person, director state resource person.
Obligement.
Compliance.
Item 15.
On behalf of Mr. Bahali, I may plead your lordship. On behalf of Mr. Bahali, I may plead your lordship. No, man. This is a contempt matter I want to ask. Yes. Here, by the order dated 21st July 2023, Honorable Court directed OP number 5 to consider the representation within a period of 3 months.
Affidavit.
My lord.
Affidavit.
I have to file an affidavit. Yes, okay, my lord.
2 weeks. 4 weeks. 2 weeks. My affidavit will come 4 weeks. The matter will come after 4 weeks. Within 2 weeks, you file an affidavit. Will it be difficult for you to file affidavit?
No, my lord.
Item 16.
My lords, item 16, that affidavit issue is there, but I undertake to file it today or tomorrow, by tomorrow.
So when do you want?
Thursday.
Thursday. Learned counsel for the petitioner submits that in view of that certain degree of urgency is attached in the present proceeding, and therefore shorter date may be given for filing of a supplementary affidavit in accordance with affidavit to support the petition in accordance with so and so. First off, list this case on Thursday.
14th, 15th.
15.
My lords, next 2 matters, same order, your lordship.
Which item?
16 and 17 and 18.
Lord, let those matters be called.
Yes.
Item 17.
17. Same order.
Item number 18.
My lord.
Your lordship, in item number 18, your lordship, I am appearing on behalf of the state GST.
I'll give a copy.
16-17, I am also appearing in 16-17. And so far as in this 18, your lordship, central government as well as the state GST, both are party. Copy may be served.
I'll serve today itself.
Serve it.
Item number 19.
I am sorry, because of my view, the members of the bar have been put to inconvenience. But that is,
I may be
have to suffer.
I am permitted, lordship. So far as item 18 is concerned, my appearance may be kindly accepted on behalf of the central GST.
Lordship, serial number 19, that the GST, in absence of GST removal, the petitioner is approaching for stay recovery of the order. The cover on the previous order only.
What happened?
In absence of GST tribunal, the petitioner approaching the honorable court for stay recovery of demand. There is cover on the previous orders also.
So the tribunal has not become functional.
Your lordship, as like as this, your lordship, there is more and more than 300 cases are pending like this, your lordship. Your lordship, fortunately, I have gone through an order passed by your lordship in Patna High Court. While your lordship was acting as your honorable acting chief justice, your lordship may kindly look into that order. In that order, your lordship has passed
by disposing of the writ petition, the same relief, your lordship, that 20 cents you have deposited 10%, you deposit the balance 20% of the balance remaining amount, and the writ petition is disposed of with a liberty granted to the petitioner to file appeal after constitution of the tribunal.
Yes.
And if not filed, your lordship, liberty has been granted to the department.
Go through this.
Your lordship, I have submitted. This order I have submitted.
The proceeding cannot be covered by
No, your lordship,
a division bench order
submitting.
passed by Patna High Court.
Your lordship, because the
Division
facts
bench of Patna.
here the same thing has been happened. Here,
All right.
your lordship.
All right. So please give him a copy of this order.
I'm giving.
We will take up the matter tomorrow.
Your lordship.
And if both of you permit us, then we may pass the order, similar order.
Your
All right.
lordship. Your lordship. Your lordship, because all the cases can be disposed of. All the cases can be disposed of, more than 300, 400 cases.
Please give the list.
Your lordship, I'll prepare a list and I'll give.
Item 20.
Get to your.
Yeah, Your Lordship, this is a case of service tax where my client got a notice from the finance department that they have to pay service tax for the financial year 2016 and 17. After 3 years, they got a notice from the financial department, and they
Can we rise for 5 minutes or even less than that?
So it is a service matter, Your Lordship, where we have been given a notice to pay the service tax for the year 16-17. And it was also complied back on 2021, on 31st October 2021, they gave us a notice for the payment of service taxes. and it was also complied back within 2 weeks.
Correct your affidavit portion first.
Yes.
Is the matter urgent?
Yes, my lord.
All right.
So
2 weeks. File a supplementary affidavit.
My lord, this matter may be remanded. We have discussed. After affidavits.
File affidavit.
Would also be appearing for opposite party no? From the central GST department.
What do you say?
Avinash Kedia.
No, what is your submission?
Lordship, in this case, it's an appealable one. The order which has been passed, it's an appealable one.
Then you can withdraw the writ application. You can file an appeal. Yes, the order is appealable.
Yes,
appealable
because the show cause notice that has not been.
They are not giving us.
Whether you will argue or he will argue.
My lord.
I'm arguing.
Okay. It's all my lord, I have just.
Barred by limitation. Appeal would be barred by limitation.
Yes.
Your Lordship, in this case, the notice was first served on 31st/8/2021. When it came to the knowledge of the department that they have the third party information they have received. So they have received. So
If he files an appeal, then what will you do? You will not oppose the appeal on the ground of limitation, will you?
let him take the stand in the appeal, your Lordship.
Who?
Let the petitioner take the stand in the appeal that he'll bar by limitations. Or let the matter may be remanded back to the assessing officer again to re-adjudicate the matter.
Why? Why?
Here, your Lordship, first.
We are required to record reasons for everything.
Okay, then I'll argue that our Lordship, this matter is an appealable one and he go for an appeal.
Yes.
Yes, we are. The order has been passed, and we have not been provided any show cause notice or.
But you got a preferred appeal with taking the same ground which you are taking here.
Yeah.
London Council appearing on behalf of the petitioner agrees that the petitioner has approached this court without availing the statutory remedy of appeal under under section 85 under section 85 of which is the act?
Finance Act 1994.
Act people. He seeks to withdraw the petition with the liberty to prefer an appeal under the said provision before the appellate authority. Stop. This writ application is permitted to be withdrawn with the liberty as sought for. First off, we make it clear that the appellate authority, while considering the petitioner's application for condonation of delay in filing appeal. Yes.
Considering the petitioner's application for condonation of delay in filing application. Considering the petitioner's application for condonation of delay in filing the application.
The appellate authority shall keep in mind the fact that the petitioner was pursuing his remedy before this court by filing the present writ application. Yes. Yes.
Item 21.
My lord, item 21, I am appearing virtually, my lord.
Yes.
Virtually, my lord. My
Please.
lord, I may kindly be allowed 2 weeks time to file the fresh affidavit, my lord.
All right. 2 weeks. When do you want the matter to be listed? No.
My lord,
listing.
2 weeks after, my lord.
This, as requested on counsel for the petitioner states that he shall be filing a supplementary affidavit in support of the averments made in the petition in accordance with the requirement under so-and-so rule within 2 weeks. To stop this matter on 2 weeks.
My lord, 4th of March.
Yes, 4th of March.
4th of March, my lord.
4th of March.
My appearance may be kept on record. I am for the opposite part. Much obliged.
Deeply obliged, my lord.
Item 22.
I may be permitted to withdraw.
It's a liberty to better application. Petitioner seeks permission to withdraw the application. A more taken on.
My lord, we are appealing for the opposite parties.
Please.
Item 23.
Lordship, I am challenge the first appellate authority order, Lordship. As per the tribunal has not been constituted, Lordship, the petitioner is not finding any alternative remedy filed.
The same 1020.
Please give the list of all such.
Your Lordship, 300 to 400 cases. I'll one day today. Your Lordship may kindly grant. I'll give all the list because in all these cases, Your Lordship, this honorable court has passed the order since the petitioner has deposited 10%.
So this matter will also come tomorrow. This.
Only 1 week time may be granted to file fresh affidavit. Please.
List this case on. List this case tomorrow along with CWJC number.
Your Lordship, that is item 16. Item 19. Sorry, item 19.
Your Lordship, I am appearing for opposite party number 1.
Item 24.
1 week time may be allowed to file the affidavit, Your Lordship. 1 week's time.
1 week. List after 4 weeks.
25.
Petitioner being the local elected sarpanch represented by the villagers on behalf of the villagers challenging the illegal, arbitrary misprisions and misprisions action of the opposite party in respect of a passage which crosses the national highway, which gives acute problem to the tribal as well as the inhabitants of the locality.
So this is public interest litigation.
Yes, my lord. Yosef has glanced to the village map, which clearly shows that from the Emerald time there is a village road which touches the NH, and thereafter the national highway has widened the 2 lane to 4 lane.
Who are you?
I am for the Sarpanch locality.
Sarpanch?
Yes, elected Sarpanch.
Huh?
Sarpanch, my lord.
So did you go to the authorities? Did you make any representation?
Yes, my lord. I have also submitted the representation to the authorities. You also have to glance to the Annexure 1 series, page 12 to 23.
These are the matters where the High Court is not required to, should not interfere. So these are. Which annexure is your representation?
Annexure 1 series, page 12 to 43, and thereafter the last grievance petition was filed. Annexure 2 series, page 24 to 32.
We shall not enter into such disputes. And this representation, first representation was filed in 2021.
Yes, ma'am.
Second in 2023. Do you have any instruction?
My lord, so far as the first representation is concerned, your lordship may see, this is addressed to the project proponent. My lord, this is the work to be executed by National Highway Authority of India, NHAI. He has not made any representation to the NHAI. First representation to the project proponent who is doing that work. And second representation is to the collector, Keunjhar. So he has to make a proper representation to the National Highway Authority that we need this sub road or subway because of these difficulties.
Why you are going to the contractor? You filed your representation to the contractor.
No, my lord, I have filed a representation to the project director NHI.
Here, Agrawala Project Private Limited, Ruguri, Keunjhar. He has to.
All right, you can make a representation. We will not enter into that.
My lord, filed a representation to the project director NHI Keunjhar on dated 7/8/23.
Apology, my lord.
Petitioner, one petitioner or no more than one? Petitioner.
One petition.
Seeks permission to withdraw this writ application with the liberty to approach competent authority for redressal of his grievances by making a representation. Stop.
If they made a unanimity party, let them serve a copy.
Dispose of.
It disposed of, but copy. Had a copy be it's only kept in our.
In this case, the representation has been made to the NHI, National Higher.
At page?
At page.
Who are you?
Well, I'm the petitioner.
Who was he?
He is my associate. So I'm the parent member and I was in election or other courts. This representation was there. Annexure 2/6. At the page 34.
32.
Representation to project director NHI.
Page.
Project at page 28. Madam.
Which annexure?
Annexure 2 series. My acknowledgement receipt. This was received in page 31.
Mister, you are referring to page 20.
28.
Yes, we are at page 20.
28, it is the application.
Yes.
And the acknowledgement receipt is at page 31.
Oh, Mister. Absolutely nothing. Make a representation before. Council after permission to withdraw his petition legal to approach competent authority for redressal of his grievance by making representation. By making representation/press representation. Raising his grievance as raised in the presented application. From this application stands disposed of as withdrawn with the liberty as sought. First off, it is made clear that we have not entered into the merits of the case and competent authority under NHAI, National Highway Authority of India, shall be at liberty to take appropriate decision in accordance with law. Stop. Let a copy of copy of the writ petition be served upon the Deputy Solicitor General for India by tomorrow.
Well, I'm sorting right now.
Item now 26.
Affidavit. How much time? 1 week? 1 week, 4 weeks. 1 week for filing, 4 weeks.
27.
Time may granted to file an affidavit.
1 week, 4 weeks. 1 week?
2 week maybe.
2 weeks. 4 weeks.
28.
May I please your lordship? Here the PL file.
All the other items. Item number?
28.
28.
My lords.
Yes, sir.
Here the petitioner before lordship filed this public interest litigation, lordship. In the on behalf of the students, lordship, the grievance of the petitioner is that, lordship, under Annex 2, page 16, the CDA Inter-School Cricket Tournament 2024, CDA Inter-School Cricket Tournaments 2024, scheduled to be held from 27 February 2024 to 25th 7 2024, lordship. And under Annex 1, lordship, page 11, lordship, during that period, lordship, the 10th examination of different boards, lordship, the CBSE as well as the BSc examination has already been scheduled by the boards, lordship, to conduct the examination, 10th examination, lordship. And if a lordship peruse the Annex 2, lordship, and Annex 1, the similar.
On which date the should be held?
Specific on each day, your lordship, kindly have a glance. The examination start from CBSE, lordship, page 11. That is start from.
According to you, which date should be fixed for these matches?
After a lordship, examination over, a lordship. After March 15th, lordship.
Suppose there is IIT examination?
No, my lordship. Here the specific participants, lordship, page 17, lordship, kindly have a glance. Page 17, lordship, kindly have a glance. The OCA mailed to the district association, lordship. The players from classes 7th to 10th can be participated in the school tournaments, lordship. The specific tournaments held for school students, lordship. The for students 7th class to 10th class will be participating in the tournament, lordship. But here the 10th examination is going on during that period, specific on the which date the tournament is fixed, lordship, started from 8:30, and on that day, lordship, 10th examination is fixed, started from 10:30, lordship. So by the process, lordship, the 10th class students, they will be affected. They can't be participating in the tournament, lordship, though they have prepared fully and for the match, lordship. For that, lordship, the PIL has been filed
Your Lordship, seeking indulgence of your Lordships to postpone the scheduled inter-school tournament, your Lordship, after March 15th, your Lordship.
And why not the examination? Examination can be postponed.
Once examination, your Lordship knows the 10th examination, the foundation of the students, your Lordship, and that can't be postponed, your Lordship. The cricket tournaments, your Lordship, can be held after the.
And who are you?
So I am a public, your Lordship, citizen of Cuttack City, your Lordship. This notification is for, your Lordship, Cuttack district, your Lordship, Cuttack City schools, your Lordship. For the interest of students, your Lordship may interfere in the matter, your Lordship.
We are thinking something else.
Yes, your Lordship.
Want that? Do you want something else which we are thinking?
No, my lords. There is no, the petition is no way connected with
We intend to impose exemplary cost in such matters.
No, my lords. It is only confined to the students, your Lordship. There is nothing is no way otherwise involved by the present petitioner, Lordship, in any manner. The students' future, Lordship, so far those students are prepared for cricket.
All right. What do you want? Not us. The petitioner.
I will approach the authorities, your Lordship, opposite party authorities.
And you have, without approaching the authorities, you have come to the High Court.
On 4th, they have issued the notification for tournament, your Lordship. And on 15th, examination will start, your Lordship. For that, there is no time to approach the authorities by written, your Lordship. But orally, they approach, your Lordship.
Have you stated?
My Lord.
Have you stated that you orally approached them?
No, my Lord.
We are dismissing this writ application with a note of caution. The petitioner in the present writ application claims to be a resident of Cuttack town, engaged in some kind of business. First off, he has further claimed that he espouses and safeguards the interests of the residents of Cuttack and promotes their causes in all matter, including those relating to civic amenities. Stop. Next. He has invoked the extraordinary jurisdiction of this court under Article 226 of the Constitution of India by filing present writ application in the nature of public interest litigation, challenging court illegal and arbitrary and court action of the opposite parties number 2 and 3 to conduct inter-school cricket tournament 2024 from 7/2/2024 to 25/2/2024 during 10th board examination, which is scheduled to commence from 15/2/2024. Post op. Next. In our considered opinion, before approaching this court, the petitioner has had admittedly not approached any of the authorities. First off, the description about the petitioner given in paragraph 2 of the 3 or 2 of the 3 of the writ petition is totally vague. First off, this writ petition, in the court's opinion, 3 and 5, the writ petition, this writ petition in the nature of public interest litigation lacks bona fide. First off, we intended to impose exemplary cost on the petitioner for approaching this court under public interest litigation with the relief as sought for, as has been noted above. First off, we, however, refrain from doing so, but we caution the petitioner to be careful in future to avoid consequences, adverse consequences. First off, this application is dismissed with the observation as noted above.
Item 29.
In this matter, Lordship, I just now furnished a corrected affidavit, Lordship.
No, this is contempt matter.
Contempt appeal, Lordship.
Contempt appeal?
Appeal, Lordship.
Yes.
So I filed just a corrected affidavit today. I filed, Lordship.
All right, take back there.
Lordship, Lordship.
You have filed this. What is the order which is under challenge?
In fact, Lordship, I am challenging Lordship. Lordship, can you say prepare small dead chat, Lordship? I am not the proper person to execute the order, Lordship.
Mr. Counsel, you have referred an appeal against an order passed by the single judge.
Lordship.
What is the order?
Lordship, can you come to page 18, Lordship?
What is the order?
Lordship, here the Honorable Court has given direction to me to implement the order where I was not the proper person to implement, Lordship. And Lordship,
see the Contempt Act, Contempt of Courts Act.
Lordship. And also, Lordship, Lordship, Section 19, Lordship, provides for Lordship. Lordship, here my humble submission, Lordship, I have filed a miscase for Lordship for recall of that order. My humble submission, before considering my application, I have been given direction to Lordship to implement the order where I am not the proper person to be Lordship to implement the order, Lordship. Immediately I have Lordship communicated the order to the authorities to implement, but I am not the proper person. That has to be considered, Lordship, by the Honorable Single Judge. That is my humble submission.
Before filing your appeal, did you consult the provisions of the Act?
Lordship, Section 19 here, Lordship, I have gone through, Lordship.
Please read Section 19.
Lordship, section 9 may read.
Please read.
In appeal shall be lies of right from any order of decision of High Court in the exercise of its jurisdiction to punish for contempt. Lordship, absolutely correct there, but my humble submission, Lordship.
Then where is your humble submission?
Lordship, in fact, Lordship, because I was not a necessary party, so I have filed a miscase for consideration of my grievance, Lordship, without hearing me.
Tell us where is our jurisdiction.
But Lordship, let's come further. I will examine further, Lordship. That is there, Lordship.
No question of.
But Lordship, may I please one. I have applied for Lordship. I have applied for there. That is my entire grievance, Lordship. I have applied for. Without considering me, that application, Lordship, under signature is insisting me.
The
Lordship, only Lordship, some liberty I will pursue there, Lordship.
Grand counsel for the petitioner, after some argument, seeks permission to seeks permission to withdraw this application. Stop. This application stands disposed of accordingly. Stop. We make it clear that we have not entered into the correctness of the order, which is the petitioner has sought to challenge in the present appeal, that present contempt appeal, as we are of the view that this appeal itself is not maintainable. Stop. Nothing else.
Lordship, only liberty to renew my prayer there, Lordship.
Therefore, we have said that we have not entered into the merits. All right.
Lordship, I'll move there. Grateful.
Item 30.
Lordship. The contempt application, non-compliance of the order passed by this honorable to running page 8, your Lordship.
Running page 8.
8.
Yes. So this order has not been complied with.
Complied with.
Yes.
Lords, I have obtained instruction. Lords, he had filed an application under section 28 capital A of the Land Acquisition Act for enhancement of compensation on the basis of award passed by the Honorable Civil Court. After getting this order from the Lordship on 6/2/2022, he had fixed a date for production of relevant documents.
6/2/2024.
Sorry, 6/2/2024. On 6th only, he was noticed for producing documents as well as the award of the Lordship Civil Court. So some more time will be required for adjudication only. That's why I pray Lordship may call it. So give me some time. In the meantime, we'll adjudicate because it needs adjudication.
You will come again by filing second contempt application.
Your Lordship, on the same ground, give more some time, your Lordship, to comply there.
It has been stated by learned AGA that for effective compliance of this court's order dated 19/5/2023, a notice has been issued to the petitioner as the dispute requires adjudication by a competent authority. So he submits that though there has been delay in implementation order of this court, the matter shall comma the what has he filed? The petitioner's application
Under section
under
28,
section 28A of
capital
the
A.
Land Acquisition Act 1984, bracketed IA number 8 of 2000.
Elena.
LA.
LA.
LA case number 8 of 2000 shall be disposed of within how much time?
So, 6 weeks time, Lord.
We are granting you more time.
Yes, Lord.
3 months.
Yes.
2 months. 2 months. Stop. This matter. 2 months.
After. Okay.
Date दे देना.
31, 30.
31.
Up to
31 and 32.
same, Lord. 30,
31, 32, 7.
Similar orders, Lord.
Similar order.
Item 33. May it please your lordship. 33 minute the order of learned tribunal was under challenge. In the last occasion, as the notice was not served, your lordship had directed me to file a fresh requisite. I have filed it. Lordship may permit me to take notice. I have filed it on 6/2/24. That may be accepted and notice may be issued.
This writ petition is of 2015.
Yes, ma'am. The notice were issued, but the AD returned with unserved with the opposite parties. That's why your lordship was graciously pleased to issue further notice, which I have filed the requisite.
Then
that may be accepted and accordingly notice will be issued by the registry.
who is opposite party number? Dependent number.
It's one Vijay Kumar Devri, who was the applicant in the tribunal. Yes, ma'am.
Where is he? Is he working?
No, well, it's that no, he's not working. Here it was directed to reinstate him. We did not do it. We challenged it before your lordship. Your lordship issued notice. Notice was returned when unserved. That's why further notice was issued. We have filed fresh requisite to notice him.
No, the whole difficulty is that the matter is pending since 2015.
Yes, Malaj. I bowed.
Despite because of non-service of notice upon
yes, Malaj.
The opposite party. So
the only option we have to send the notice and the address he has disclosed in his petition. There is no other option.
Oh, you also should verify.
Malaj, I'll verify.
Present address, correct address.
Malaj, that is the address available.
Duty. No. This is your duty also.
Yes, Malaj.
To ascertain.
Malaj, I'll ascertain. I have specifically written letters to find out whether this is the address. In the official record, this is the only address we have.
No, you should. You should also, not you, your client should.
Yes, Malaj.
So,
Malaj, Lordship may allow me 1 week time.
See, this petition was filed in 2015.
Yes, Malaj. Yes, Malaj.
We are in 2020.
Malaj, Lordship may.
He was directed to be reinstated.
Yes, Malaj.
He has not been reinstated.
No.
So how do you expect that? Since 2015 because the notice could not be served upon opposite party number?
Sole opposite party.
On the sole opposite party. Full stop. It is the submission on behalf of the petitioner, Union of India, that the requisites were filed for service of notices upon What sole respondent? Vijay
Kumar Dehuri.
and others. Who are others?
Well, it's others. Only sold.
No, the cause title it is mentioned. Upon the sole opposite party with the address available on record. He is not in a position to state as to whether any verification has been done as regards his present and correct address. Correct and present address. From he is resident of which place?
Well, it's Dhamnagar, Bhadrak.
You are Union of India, I think. Which district?
Bhadrak is the district.
Bhadrak district.
Bhadrak, yes.
In the exceptional circumstance, we direct the superintendent of police Bhadra district to inquire as to whether the opposite party resides in the district, in village.
Well, it's village Bellamalo. Bellamalo.
Bellamala.
Post Dobal.
Dobal. In the district of Bhadrak. Or not. Stop. Let the report be filed by 2 weeks. Let this matter on 2 weeks. So after the order was passed by the tribunal,
yes, my lord.
He did not approach.
No,
even for
no, my lord. Otherwise, he would have filed contempt also because there was no interim order.
He had filed contempt.
No, my lord. That instruction was also got. We have not filed.
But what can we do? We cannot interfere with the order on that ground.
No, my lord, I understand, my lord. So far as his present status is concerned, by the next date, I will get the.
And you also inquire.
Yes, my lord. I'll do that. I'll do that. Because we have written specific letters to find out the exact address. On the official record, it is the only address available.
Oh, no, not only. All right.
I'm okay.
Item 34.
My lord, I am in VC. My lord, in item 34, I filed a memo for withdrawal, my lord.
Counsel for the petitioner who has any objection?
No, your lordship, I am for OP 1 and 2. My name may be recorded, your lordship.
Current counsel appearing on behalf of the petitioner online, petitioner who has joined online, seeks permission to withdraw this writ application. Memo?
Filed, my lord.
This writ application is accordingly dismissed and withdrawn. Learned counsel for
OP 1 and 2.
P1 and 2 is present.
35.
My lord, this is an appeal by the state against the judgment of the Honorable Single Judge under Annex 1, my lord. It starts from page 13. May I take, my lord, to page 13?
Page 30.
13, my lord, 1-3.
1-3.
My lord. The order starts from page 50.
Yes.
My lords, may I take, my lord, to page 16, para 6.
Yes.
It is further contended that similar matters has also come up before this court in OGC number 2147/91, which was decided on 24/3/92, and this court has considered the case of job contract employees for regularization of service and for pension and pensionary benefits. In OA number 3020C of 2003, Nityananda Biswal versus State of Orissa and others, the tribunal had order dated 4/1/2004 also directed that the period of engagement of the petitioner in job contract establishment should be taken into account as qualifying service, and accordingly his pension and other pensionary benefits be revised and paid to the petitioner therein. The order passed in OA number 3020C of 2003 was also challenged by the state before this court in WPC number 14244 of 2006. This court by order dated 9/4/2014 dismissed the writ application preferred by the state against the order passed by the tribunal. The state also preferred special leave as appeal number such and such against the order passed by this court in WPC number 14244 of 2006, which was dismissed by the apex court by order dated 13/7/2015. In view of the above settled position of law, my lord, para 7, nothing remains to be reconsidered by this court. Accordingly, the opposite parties are directed to extend all such benefits in favor of the petitioner in terms of the direction given by the court as mentioned above, as expeditiously as possible. My lord, in essence, this honorable court has directed that the entire period of job contract establishment to be counted towards pensionable establishment. Ma'am. May I take, my lord, at this juncture to the rule, ma'am?
No. The rules have not been referred, only decisions have been referred.
Exactly, ma'am. That's why I was taking my lords to the rules. There is a rule saying it cannot be done.
No, but the court has directed whether what has been mentioned in paragraph 6 is correct or not.
It is correct, ma'am.
Then the court says that similarly, same treatment should be given to this petitioner. No.
In a similar matter, before the Honorable Apex Court, now we have the Honorable Apex Court has been pleased to grant stay, ma'am.
There was a regularization order.
Well, the entire job contract establishment period is to be regularized. That is the direction, ma'am. Yes, my lord. That order, my lord, may kindly see this.
And which order has been stated?
My lord, the order to regularize taking the entire job contract period towards the pensionary establishment. Because the rule is, my lord, only that period which falls short.
Mr. Counsel, whether those rules were considered in these orders or not.
My lord, those rules were not considered.
Those rules were not taken into account in the cases which have been referred to in paragraph 6.
No, my lord. Rules have not been taken into account.
But still those orders have been approved by Supreme Court.
My lord, because on delay, on the ground of delay only.
Then?
That is a factual position, my lord. I cannot, that is the factual position.
And you must have extended the benefit to similarly circumstanced persons.
My lord, in all those cases, except barring 3 or 4, we have approached the Honorable Apex Court.
The difficulty is that you will have to satisfy us that this order is legally infirm, which has taken into account previous decisions of this court and has followed it.
I'll try to do that.
So this learned single judge was duty bound to follow.
My lord,
he has followed.
My lord, only question is that the rules should have been taken into consideration, my lord. A rule governing the field ought to have been taken into consideration. That is my humble submission, my lord, to this honorable court. If a rule doesn't...
The whole difficulty is that whether the single judge could have taken a different view than what was taken by a division bench of this court.
My lord, may kindly see. My lord, may I take my lord to the page 15 of the order. My lord has seen that.
Yes.
So it was, my lord, disposed of on the very first date because the honorable court relied upon the petitioner's statement that it is covered. My lord, but those orders and this honorable court was made to believe that yes, it is similar.
So have you taken this ground?
Yes, my lord.
That the order was passed on the very first day
Yes, my lord, I have stated so.
in your memo of appeal. Whether counter affidavit was filed in that case or not.
No, my lord, it was disposed upon the very first date. The writ petition was disposed upon the date of admission, fresh
Show
admission.
us from your memo of appeal whether you have taken this ground. Or whether all those orders are there on record or not. The orders which have been referred to, there are to paragraph 6. They are there on record or not?
In this writ appeal, my lord. No, I have not annexed.
Then how can we see?
I will annex them, ma'am. I'll annex.
And did you find from your memo of appeal?
My lord, we have not stated so.
You could take this ground specifically.
My lord,
This,
which it's not there. My lord, will permit me to bring all these orders. At least, my lord, let my lords may decide at least one case at least, so that, because, and my lord, a bench of this honorable court has decided otherwise, my lord. The question is, that's what I want.
Mr. Counsel, in no circumstance we can take a different view than what has been taken by a coordinate bench of this court.
My lord.
So if we are required to differ, then we will have to refer that to a larger bench. So if a coordinate bench has taken a different view than what was taken, it's a different matter. We will see both the orders.
My lord.
But we need to follow the.
I have a judgment of
judicial
this honorable
discipline.
court which deals otherwise, man.
Deals otherwise, then we will see.
And which says that no, they are not entitled.
It is after noticing these orders.
Yes, ma'am. The judgment is the only of.
All right, we will see. An order of learned single judge dated 4/11/2022, passed in WPC 28626 of 2022, is under challenge in the present appeal. So stop. Relying upon certain decisions of a coordinate bench of this court, which have been referred to in paragraph 6 of the impugned order, learned single judge has granted the relief to the opposite party.
I was opposite part number 1.
Opposite party.
The appellant number 1 here.
Stop. It is submitted on behalf of it is submitted by Mr. Prasanna Kumar Mohanty, learned ASC, that the impugned order passed by the learned single judge has not taken note of the statutory provision under Rule
18(6), ma'am.
Rule 18 bracketed 6 of
the Orissa pension rules.
Of the Odisha pension rules. Must be
1992.
1992. So stop. The learned counsel for the learned Mr. Mohanty submits that he will be bringing on record the said orders passed by coordinate bench of this court and another decision of another coordinate bench of this court for just adjudication of the matter by next Monday. Well, stop. Let this case on next Monday.
My lord, only one correction. My lord said Prasanna Mohanty, I am R.N. Mishra, Rabnaran Mishra.
Oh, sorry.
Additional government advocate.
I have a very poor memory of names and faces also.
No, it is definitely Mr. Prasanna Mohanty.
Yes. Every time I commit the mistake, I would expect the members of the bar to condone that.
I have not yet appeared before my lord, so naturally.
Item 36.
My lord kept it to Monday.
36.
My lord kept it to Monday.
Next Monday, yes.
It states writ application was challenging and the award passed by the learned Miller's labor court. The lawsuits apply the same for Miller's analogy to us. I have to file an affidavit, Miller taking all these grounds, Miller's within 2 weeks.
2 weeks for affidavit. We'll start for 4 weeks.
No, we have been complying with your latest section 17. We have been paying him the amount.
Item not.
Yes.
Item 37.
May I please, your lordship? The matter is, the issue involved in this writ petition is related to WPC number 20526 of 2014. Kindly call the matter along with this matter, so this. Kindly call the matter next week along with the WPC number 20526 of 2014. The issue is involved in the same matter.
What is this about? So have you been disengaged?
No, till now I am continuing. Till now I am continuing in this. So I have filed this two miscase IA for to implead the serpent, next serpent, the village is constituted another serpent, so implead the serpent as a necessary party and to.
You want this matter to be listed along with which case?
Along with this 20526, this is the main case 20526 of 2014.
That is the main case.
That is the main case.
And this is not the main case.
No, it is, these are the not main case 2012586. These are not main case. Main case is 20526 of 2014.
What is the difference between main case and subsidiary case?
Subsidiary case, the issue involved in these case, all are praying for granting minimum wages to the employee. This is the main. And
the main case has also been filed by you.
Main case.
By you.
No, main case I have not filed.
Then why this case is not the main case? All right. As requested on behalf of the petitioner, that the matter be listed along with
WPC number 20526 of 2014.
That is the only case.
these cases related to these three writ petition is also related in this case. 12586, which are already in the file, 12586, 12587, and 12588. These are also related. These are already in the file.
Petition coming.
The read petition last coming, my read petition last coming in the 18, 12, 19.
Counsel for the petitioner shall be at liberty to make a mention after giving notice to learned counsel who will represent the petitioners in the other case in WPC number so and so जो पहले है for expeditious hearing of the case. All right. You inform him that this case has been directed to be listed along with the other case.
Yes.
All right.
My lord.
Then you also inform him that you have been given a liberty to make a mention for early hearing of both the cases.
My respectful submission is they kindly fix a date so that I can inform them earlier.
We will not fix date because he has to be informed.
Yes,
you want his case to be fixed, which we cannot do.
Their case has already been disposed of, my lord. All the cases has already been disposed of.
Are you talking?
Yes. A lead case has already been disposed of.
Then why did you want this matter to be listed along with
I pray to them, I pray the same with the same light of the same order, I pray to dispose of my lead petitions so that I can.
Where is that order?
But that order has been passed in 20526 of 2014.
Where is that order?
Order copy I have not got.
Order copy you don't have?
No, I have not.
Don't do that.
Can you call the matter next week so that I can.
That counsel for the petitioner has argued that a similar matter that is WPC number so and so has been disposed of by this court by an order dated. Give the date.
18/8/2023.
18/8/2023. And this matter may also be disposed of on same lines. So stop. List this case on next Monday, Tuesday, along with copy of the order passed in WPC number.
Item number 38.
I may please your lordship. Item 38, your lordship, also suffers from the same defect of affidavit.
Do it.
I'll seek an adjournment to rectify the same. So also, your lordship, the state has already filed a detailed counter. Need further time to file my rejoinder to this.
And counsel appearing on behalf of the petitioner has made two submissions. He submits that he is required to file supplementary affidavit to duly support the averments made in the writ petition in accordance with the requirement under Rule 3 of Chapter 6 of Part 2 of the Odisha High Court rules, whatever. Odisha Jury High Court rules. Stop. He secondly submits that a copy of counter affidavit filed on behalf of the estate has been served upon him, which he is required to consider and file a rejoinder and file rejoinder. So, list this case on 4B.
Yes, sir.
4B. Stop. In the meanwhile, the counsel for the petitioner shall be at liberty to file the supplementary affidavit and a rejoinder to the counter affidavit. Yes.
Much obliged.
39.
Item 39, my lord, I have received the copy of the counter last occasion. I will file my rejoinder.
We have filed our count.
Yes. 2 weeks time.
2 weeks' time is allowed for a filing of a rejoinder to the counter affidavit, which has been filed on behalf of the estate. 2 weeks' time is allowed to learn counsel for the petitioner. So, because this matter on 4 weeks, in the meanwhile, learn counsel for the petitioner shall be required to file an affidavit supporting the averments made in the, verifying the averments made in the, verifying the pleadings made in the writ petition in accordance with so and so rule. Yes.
Obliged.
Really sorry to trouble the court again. I had mentioned the matter in the morning, the Admiralty matter. It's registered.
Next. 5 minutes here. Beginning was very So you have got the number?
Yes, sir. Yes, my lords, we have.
Yes. So let me understand the jurisdiction first.
Yes. Matter will go before my lords ideally. Yes.
The ship owes you money.
Oh, yes, my lords. These are port dues that they have not, my lords, paid. So it's a maritime lien, as my lords are aware. And maritime lien, my lords, is.
We are not aware. You tell us the section, you tell us everything.
Yes.
Yes, we don't know anything.
Yes. So, my lords, to start with, just to clarify, my lords, your lordship may look at the cost title. It will indicate that the vessel is in the Paradeep port.
Record not came. On it. Not required.
Just since it falls from my Lord Justice Arindam Sinha, just to indicate, my lords, section that is applicable, my lords, is section 41N, which is a maritime claim. And since it is a maritime, every maritime claim is not a lien, but every lien is a claim. So section 91D is the section, my lords, which confers, which treats this maritime claim as a maritime lien. I have it. But if the act is required, I have spare copies.
Yes. So you want arrest of the vessel?
Yes, my lords. The power to grant arrest is in section 5, my lords, as my lords are aware.
Section 5?
Yes, my lords. If I may just read, my lords. The High Court may order arrest of any vessel which is within its jurisdiction for the purposes of providing security against a maritime claim which is subject of admiralty proceeding, where the court has a reason to believe, my lords, A and E is applicable, where the person who owned the vessel at the time when the maritime claim arose is liable for the claim and is the owner of the vessel when the arrest is effected. And E, the claim which is against owner, demise charterer, manager, operator of a vessel which is secured by a maritime lien as provided under section 9. And section 9, my lords, will indicate that this is a maritime lien because this is a terminal due, my lords, the port's due. Section 9(1)D, if I may invite the court's attention.
Yes.
9(1)D, my lords, every maritime lien shall have the following order of intercept priority, namely D, ports of claims of port, canal, and other waterway dues and pilotage dues and any other statutory dues related to the vessel. So, my lords, port, it's a claim of a port, the terminal of a port. And, my lords, just so that, my lords, I satisfy, the definition your lordships will find in section 2(1)G defines maritime lien.
No, but you are addressing on merits.
No, I'm just indicating the jurisdiction. And your lordships will see section 3 defines jurisdiction of this court, of every coastal court with regards to the waters abutting the state. Your lordships will find section 3, subject to provisions of section 4 and 5, jurisdiction of all maritime claims under this act shall vest in the respective high courts and shall be exercisable over the waters up to and including the territorial waters of their respective jurisdiction in accordance with the provisions of this act. So, my lords, Paradeep comes, my lords, within the territorial waters abutting, my lords, Odisha, and accordingly, my lords,
the ship.
Paradeep port.
What is your claim?
My lords, it's for, my lords, payment of terminal dues, which are port dues.
It comes under which provision?
My lords, section 4(1)N read with 9(1)D.
M.
41N, N for Nagpur, my lords.
Who are you?
My lords, I am a port's terminal. The vessel was, my lords, within my terminal. It berthed at my terminal, my lords, for the purposes of, my lords, loading, unloading cargo.
And from there it came to Paradip.
No, it came to Paradip for carrying out discharge operation.
Where did this claim arise?
At Paradip.
The ship is due to leave on?
My lords, it can leave any moment unless it obtains.
On the ship. Have you raised your claim on the ship?
Yes, my lords, we have, my lords.
Where's the record?
My lords, we have this, my lords, in the morning I mentioned, my lords, so that the matter can be assigned.
Yes, Your Lordship, this was actually a single judgment.
Do you have the rules?
Yes, my lords, I have the rules framed by your lordship's court.
Yes. Because I have the rules.
May I tender?
Rules under this act?
Rules framed under section 16, subsection 2 of this act. Every high court frames rules. So, my lords, even the Odisha High Court has framed rules. Lords, all right. So your lordship's court is taking it.
Yes, yes.
I'm ready.
Why?
No difficult. It's a privilege for me to address.
Yes.
I'm ready.
You are from this court?
No, my lords, I'm from, I predominantly practice in the Bombay High Court. I'm ready. I'm obliged.
Item number 40.
My lord, I am Mr. Manti, amicus curiae for this box trade. In this, this is so motive BIL by this honorable court, where I have been appointed as an amicus curiae for box trade.
My lords, I appeal for opposite part number 2, the municipal corporation. The short background of this public interest litigation is this, that Cuttack being a very old.
You are for whom?
I am for opposite part number 2, the Cuttack
Municipal Corporation.
The background, my lords, because of the age of this city, there was no sewerage network proper. Therefore, in 2006, with the assistance of the Japan International Cooperation Agency, there was a plan and proposal to construct a modern sewer line across the city. Due to construction of the sewer line across the city, there was digging up of roads. They were in a very bad shape. That's why this PI, for taking care of the entire road network of the city as well as the sewerage network.
That has been done, completed.
No, my lord, it's
It is
still
in the
going on.
process.
Still going on. It's due to be completed, at least the main part by 31st of March 2024. Thereafter,
Which is the last order?
Last order, my lords, is 11/1/2024, order number 33.
Yes, you can sit down for a while, you are old person. Please give him a chair.
Sir.
In fact, in such proceedings, normally,
My lord.
even the respondents want some order from the court.
Let's, my
So-
lord's, my lord's previous order was to, there is an advocates committee also formed by this.
That strengthens your,
My, my. There is an advocates committee formed for examination of the status of the roads that are being repaired. My lord's last order, well, they had furnished 2 reports. Because in Cuttack city, there are various agencies taking care of this work. Cuttack Municipal Corporation is one. And the state government's road and buildings department, which is PW2, is also another one. So there were 2 different reports furnished by the advocates committee. On the section of roads to be repaired by the CMC, they had furnished a separate report. On the section of roads to be prepared by the R&B department, also there is a separate report. I believe my learned senior colleague has already prepared an affidavit for the R&B department's portion of the work. I, for CMC, had to give 2 affidavits today. One was relating to an interim application that is at flag 60, I think, in my lord's list. Flag 60, my lords. IA number 424 of 2024, flag 61. That affidavit I've already tendered. I filed it on Wednesday on the 8th, but that is not on record. It has to come on record. The second part of the affidavit that I had to respond to the advocate.
so what was the last order passed? When was the last order passed?
11-1.
My lord, so far as state government R&B department is concerned, in the last order, there was a direction that there is some shortfall pointed out by the advocate committee in their report, and you have to file a compliance affidavit to that. So far as these shortfalls are concerned. Today, I have prepared a compliance affidavit. In some cases, we have already complied. I will serve a copy to my learned friends who are the members of the advocate committee. And some works are going on, and so in respect of some roads, we are unable to commence the work because of the WATCO is doing the work digging of roads. So these are the status. I have given the entire status of the, as has been pointed out by the advocates committee. This affidavit today I am filing. It is already filed by me in the website of High Court. It is, perhaps it is not brought to the court. I am serving a copy to the advocates committee. Let them respond to this affidavit. That's all.
My affidavit, my lords, I have filed 1 affidavit in response to IA number
So
420.
you are CMC
He is PMC, I am state.
and you are state
State.
department,
R&B department, roads and buildings department, number 1.
roads and vigilance.
Buildings.
Buildings.
R&B.
My lord, I am amicus curiae for particular JICA project of box drain, which is a very critical designs of 3.49 meters, 3.5 kilometers. And this is going through the main city. And where the drain is, when we are digging drain, 36 feet below ground level. So the buildings are to be collapsed and all this. So it's a highly technical JICA project. And you'll be glad to know, after the Honorable Court interfere, out of 2,590, we have completed 2,394 kilometer mile. And this will be inaugurated by, as I heard, Honorable Chief Minister by 20th of this month. Rest 194 meters, which is being rest up to Chhatrabazar, that will be completed by March. And next comes the open drain, because that was in a box drain. Open drain, box drain was not possible in 810 meters, my lord, because both the sides there is buildings. It is very difficult because they have to evacuate. The building will be collapsed. So we are making that there will be an open drain. And Mr. Mahanti, he has from the inhabitants of this that open drain should be covered and all this. He has given an affidavit. And that I have also examined. I have also discussed with the CEO of WATCO and also the urban secretary. They have assured me that once that work up to Chhatrabazar is completed, the technical team of the WATCO as well as the JICA consultant, they will be taken together. What will be best done as per their affidavit. They will take the government approval and that will be started after the March. And up-to-date report I have already
Those
submitted.
documents come first, the pleadings, those pleadings come first, which have been filed.
Yes, sir. I have given my status report till date.
Have you seen this?
Yes, yes. No, they will not. I have given a copy to Watco and also the.
No, have you seen?
No.
The report which has been submitted by.
No, I am not giving to them. I have not given to them.
Because, my lord, the issue which is being handled by Mr. Mohanty, that is between Watco and Mr. Mohanty. Watco is the agency who is doing this, executing this work, box drain work. Watco is appearing, Mr. Bhuya is appearing for Watco.
Copy. Thank you.
Watco, Mr. Bhuya.
I have given a copy to Watco.
Yes, madam. Make few copies.
May I just clarify, my lord? As I was saying.
Just a minute.
My lord.
What is this? Works of box drain from Pata Pola to Professor Pata.
My lord.
Yes, sir.
I'll just clarify what has happened. The perennial problem of the city was, since there was no drainage sewerage proper network, all the drains are surface drains. So the idea, my lords, is now under this short-term loan by JICA to construct an entire sewer network and take all these drains underground and build roads on top of them. To do that, there's this concept of a box drain is being developed now, what my senior was presenting. That box drain is what my lords are right now seeing. So it is a huge open drain. So the idea is now to take it below and to construct a complete road on top of that so that all the surface drains are now covered and there is no open drain in the Cuttack.
All right, so what the report says that all works of this drain from Pata Pola to Professor Pata
Is completed.
will be completed by 20th of February.
Yes, my lord, yes. It is going to be inaugurated.
So it is being completed in sections. So in that particular section, what it's referring to, that section is going to be completed by the 20th.
This section is going to be completed
By 20th
of February.
Yes.
Yes.
All right,
Yes.
we can fix this on 21st of February.
Yes, ma'am.
And rest 194 meters.
194 meters.
Yes, from Professor Pada to Chhatra Bazaar Talgad.
194 meter.
So, what is your response to this?
Learned Counsel, Mr. Bhuya is there. I prefer CMC because Watco is Water Corporation. That's a separate agency that is carrying out this work.
From Professor Pada to Chhatra Bazaar Talgad.
Yes.
Mr. Bhuya, my lord.
Mr. Bhuya is the Watco. He is representing the Watco.
It will be completed by 31st March 24.
24.
Yes.
So what is left?
This is 194 meter only.
Open.
That will be completed.
If this is completed, then what more is left?
My lords, the
810 meters.
Open.
The total 810 meters, the residual part. Apart from this, that will be left.
800?
10 meters. 10 meters.
That is open drain.
That will be open drain.
They are
Instead of
saying it is in the open drain. In fact, originally it was start from Potapol to Matrubhavan school. So that was the original project which has been given and it was started since 10 years back. Since 10 years to till date, it is continuing. Now they are in phasement, they are going to complete the same. They will,
So about that, 10 meters also, there is a report that it has just started.
just right. But they have changed the plan from box drain to open drain. The purpose of the drain is, my lord, what my learned friend is submitting. So far the drain,
Where is it?
the government authority,
What government? Sorry. So what the court should do?
my lord, originally the plan was from starting point to ending point of Matrubhavan.
Why have they changed it?
My lord, I have,
Reasons, my lord.
my lord, I have told the reasons.
Different aspects, the court cannot substitute their.
My lord, for that purpose, my learned senior has been appointed as
My
amicus
lord, it's
curiae.
such a critical work. This without interfering this honorable court, this work would have been continued for another 5 years. It is because the honorable court has interfered. This work is be completed by March.
In this is 310 meters, 810 meters is left.
Yes.
That will be our submission is for the purpose, it can be covered drain.
Yes.
One is open drain, another is covered drain, and third one is the box drain. So far the box drain is concerned, it is widening the road and underground system, storage and drainage system will be there, and above of that vehicle can ply. So far this 810 meters, if at all it is not practicable for any other reasons, that or maybe, it can be covered then. Otherwise, the same problem, the same, the hygienic system, everything will be a
Sir,
problem.
what I have done, they have given that proposal also. I have discussed with the Vatka authority CEO and also the urban secretary. After this work is completed in March, they will take up with this their technical team and JICA consultant has to come, take the participate, whether the covering is possible or not. That they will examine it. But one or Lord, as I know, we have more mentally decided after the open drain is completed, we'll try to cover it as far as possible.
You cannot force them to do something which is impossible.
As per the plan and program,
No, it is not possible. It is not possible, my lord.
Which is not feasible.
It is not technically feasible.
My lord.
We have,
Yes.
this jurisdiction has limited scope. The court cannot say that you do this, you don't.
No,
do
we are
this.
conscious, man. We are the inhabitants of
My lord, I am
particular
an
two wards.
I am an engineer, my lord.
1 minute. Yes, my lord. My learned senior has got the vast experience. At the same time, if at all it is practicable for such a period and which has been given by the report of the IIT, and they have considered from the starting point to ending point at the midst of this working culture, now they are saying something, and so far this open drain is concerned, definitely it will not solve the purpose because part of the drain will be the box drain, another part, it may not be possible for the box drain, then it can be covered drain also. We are not on the other point. Because of the hygienic purpose, congestion purpose, this can be done.
Sir, I have already discussed, we will take up with this matter.
If
And
they are taking
if
it
it
in
is
a positive
possible, we will get it done.
Absolutely, we have no.
I have already talked to CEO, I have already talked to the urban secretary. I have also visited the site. I have also explained and all the environment, it is not possible to dig it.
Here, council. And the amicus curiae has submitted before this court status report on box drain purchase bracketed AIGA works as on 10 to 24. Which reads as under. So, council representing Cutter Municipal Corporation. And the state government Department of Roads and
R&B.
Roads and Buildings do not dispute what has been mentioned in the status report. Is correct?
Yes, your lordship may note the London Council for Watco also, because Watco is the executive agency. Yes.
You don't dispute.
No.
This
Yes, this is what he has submitted, that is correct.
They have, however, informed this court that affidavits have been filed.
Yes.
I have to file one. I still haven't
I have
filed.
filed one, it is not brought to record. Yes.
Mr. Mohanty has filed one that is now being taken on record. I have to file two. I have filed one. I have to file one.
They have already informed State Council has informed that an affidavit has been filed on behalf of the department online.
Yes.
On
Today, two dates.
itself, which is not there. Council for the CMC also proposes to file an affidavit giving the latest status. From the submissions advanced on behalf of the parties in the present public interest litigation, it appears that there is some sense of dissatisfaction over the respondent's decision to have open drain of 810 meters. Of the it has been argued that keeping the part of the drain open will not serve the public purpose.
Exactly.
Public purpose. And if it is not technically feasible to have box drain for the said length, the respondents should consider covering the top. Noted council representing the what is your stand?
Our stand the same thing, notes. We are, because of the amicus query, they are also discussed with the government.
No, whether you plan to cover it or.
Sir, it is not decided
It is not decided, technical committee.
Council representing the WATCO. What is that? WATCO?
Water Corporation of Odisha.
Water Corporation of Odisha, Secretary WATCO, submits that the technical aspect of covering open drain expected to be completed by 31/12/2024, which shall be examined and
with the help of JICA,
the
In consultation with
In consultation with JICA.
In consultation with
JICA.
JICA.
Yes, ma'am.
JICA. Japan International Cooperative Agency.
Japan
International
Cooperation Agency.
Cooperation Agency.
Agents.
Agents.
Anybody appearing? Who is appearing for?
They're the funding agents.
They are the
They're
funding
this
agents.
project.
It is
They're not
being executed by.
But they all the work, they first we examine and give them, then the consultant sees it, then they make it okay, then the work will start. Then only they will give the funds.
We are fixing it for, say, second of April.
Obliged.
My lord, obligement.
Second of April is this day.
Yes. So that the work will be completed. Yes, sir.
Tuesday. So on that day, we will be closing everything except 810 meters.
That, yes, ma'am.
All right.
Yes, ma'am.
So the proceeding will start for
Yes,
that
ma'am.
only.
Yes, ma'am. Obligement.
This matter or. We are not posting it for the first of April.
My lords. My lords, I am appearing in person, my lords. I am appearing in person, my lords. I am flag 61, my lords. My learned senior, the CMC has filed an affidavit, my lords. I need to have the WATCO is to file an affidavit with regard to the sewage system, my lords, because I have been completely abandoned from being utilized of the sewage system, my lords.
Why?
My lords, I'm a resident of that ward no 50. It comes under that purview of the CMC area. Order, my lord, on the last occasion, my lords, IA number 424, my lords.
This for individual grievance.
Yes, my lords. I'm appealing for the locality, my lords. Person of the locality. Yes. On behalf of, I am also a resident of that area, my lords.
Well, his grievance is that there is no drainage connection from his residence to the main drain. Therefore, there is a lot of issues that is happening there. So, he had filed an intervention application that is at flag 61 of my Lord's brief, to which I have replied. I have responded to his interim application.
Yes.
Very difficult.
Yes, my
Otherwise,
lord.
we will have to deal with one interlocutory application, intervention application.
Yes, my lords, I understand because the sewage system has, I have been, yes, my lords. Yes. Let us, in the meantime, my lords, let the sewage sisters, the WATCO may file the affidavit, my lords. The lordship may direct for that. The lordship may direct it.
Item number 41.
May I please, Your Lordship? If this rate appeal has been preferred against the order upon which single judge, my lord, I am filing the dead chat along with the written note submission. Lordship, my lord, the
Yeah.
It's even the date chat along with the written note of submission. Your Lordship, the date appeal has been preferred against the order of Honorable Single Judge, my lord, wherein the dismissal order of a constable working in CISF was set aside. Your Lordship, may I have a glance over the date chat, my lord? May I have a glance over the date chat? Just I have given it. On 13/8/1993, the respondent joined as a constable of CISF.
No, what is your ground? On
Ground
what
by
ground the order of dismissal has been set
The
aside.
Honorable Single Judge has given a finding that the disciplinary proceeding was initiated ex parte. Therefore, the same was also confirmed by the appellate authority as well as the revisional authority. Therefore, it was set aside and remitted back to the disciplinary proceeding. My grievance is, Your Lordship, may come to the impugned order, Your Lordship, that is under Annexure 1, page 19. It starts from page 19. Before that, certain dates are very much required, Your Lordship. Fact is that on 13/1/1997, the respondent was sanctioned for a 15 days casual leave. He was supposed to report back on 1/2/1997 now, but he did not report back. Therefore, several correspondence were made, notices were issued, but no response came from the respondent. Therefore, on 1997, charge sheet under Rule 34 was issued to the respondent willfully overstaying for leave with effect from 1/2/1997. The same was acknowledged by the respondent on 8/12/1997. On 1/5/19, memorandum of acknowledgement of inquiry report was sent to the respondent. Then no representation was filed. On 14/5/1998, dismissal from service was awarded after conclusion of represent proceeding. After 8 years, on 1/6/2006, the dismissal order was passed on 14/5/1998. He filed appeal before the appellate authority on 1/6/2006. After 8 years, my lord. Then same was dismissed on the ground of limitation, since the appeal was supposed to be filed within 30 days, but it was filed after 8 years. In that appeal, he has given four medical certificates that he was prevented by sufficient cause not attending the dismissal proceeding as well as filing the appeal within the period. He has given, Your Lordship may turn to page 36 of the brief, my lord.
The order was passed in 1998.
98.
So that was communicated to him in 1998.
Yes, my lord.
How do you say?
Yes, Your Lordship. Yeah, I'm just pointing out, Your Lordship, the writ application which was filed by the petitioner, my lord. He says that I am aware of that dismissal order. Your Lordship may turn to page 28, my lord. The writ application which was filed by the respondent. Para 6. That in the meantime, several call-up notice was sent to the has Your Lordship got it?
Yes.
That in the meantime, several call-up notice was sent to the applicant directed to the report back immediately, failing which dismissal action will be taken. It is the pleading of the petitioner, respondent, my lord, that since the petitioner was under treatment at Ranchi for which he was not in a position to give reply, all call-up notice for which the opposite party 5 by order dated 1997 proposed to hold on inquiry and directed to submit explanation within 10 days. Copy of letter such and such is annexed. That when no explanation was given by the petitioner dismissal proceeding, he was initiated against the petitioner for overstay leave and unauthorized absent. It is submitted the petitioner was under treatment at Ranchi at the time for which on 5/2/98 Inspector CSA such and such Najira was appointed as inquiry officer and directed petitioner to attend the inquiry on 18/2/1998. Since the petitioner was absent in the inquiry, as because
just a minute.
yes, madam. Other side is up.
Your Lordship, kindly have a glance the page 22 of the impugned order, where the Honorable Single Bench has held that it is in this view.
File your appeal 8 years after passing of the order.
My lord, the respondent was mentally disordered. He was at treatment at Ranchi. So after recover medical found fit, thereafter he has submitted the appeal. They have rejected on the ground that there is a time bar. Review, revision of appeal, all are dismissed on the same ground, madam. After recovery, I submitted my appeal, my lord. And that is why the Honorable Single Bench has, you will also kindly have a glance at para 5 of that impugned order. It is in this view of the matter, this court, while disapproving the ex parte closure of the dismissal proceeding, further looking to the medical support with the petitioner completely preventing him attending the proceeding, interfering with the order at Annexure 6, that is order of dismissal. Set aside the same. It is for the interference in Annexure 6 and setting aside.
Medical support,
Madam?
medical report.
Medical report, that is your lordship's that is annexed to page 36 and 37.
Of 8 years after order of dismissal.
Madam, since he was mentally disordered, that is why he filed the appeal after recovery. After the doctor found him fit, thereafter he has submitted the appeal, madam.
And each doctor was treating.
At Ranchi, madam. Dr. Ashok K. Prasad.
Why did you not report back for duty?
Madam?
After your leave was over, why did you not report?
No, I was, I have submitted the letter, madam, to the authority. And the Honorable Single Judge has reopened the matter and directed to file an explanation. I have already submitted my explanation. That is the order in the, as the disciplinary proceeding is required to be reopened, this court, while remitting the matter to the disciplinary authority for fresh inquiry, involving the charges against the petitioner here, and direct the petitioner to submit his explanation to the charges level against him.
Fortunately, Mr. Counsel, the point which you are taking, the ground, maybe ground for dismissal or your removal from service.
And another.
Why should, is this a paramilitary force?
CIS, sir.
Why do you want to be a member of paramilitary force? Why should you be allowed?
And another thing, you'll also kindly have a glance that punishment order page 49. Page 49 for a moment, kindly have a glance. Due to the unauthorized absence, dismissal was passed, madam. It has been mentioned the entire leave period will be regularized separately, whereas the unauthorized absence period from 1 to 97 to 3 days is regularized by granting him EOL, extraordinary leave. So the decision of the Honorable Appellate Court, that is State of Punjab versus Bakshi Singh, when the unauthorized period has been treated as a leave, so there is no misconduct. And that decision is, you will also kindly see that decision. And on that grounds, the order of dismissal has been set aside, madam. Madam?
Which part?
The first paragraph that the respondent was a police constable in Punjab and was dismissed from service 1698 after the regular department inquiry on the charges of unauthorized absence from duty. This order was challenged by the respondent in the suit filed by the trial court on 16/7/90, which was decreed on 12/5/93, and order of dismissal set aside. And it was found by the trial court that the madam, first para, madam. The decision of first para, madam. Last para, lordship kindly have the last para.
Law. How are you relying on them?
No, here that
It was case where suit was instituted against which first appeal was filed, second appeal was there. Against that, the state of Punjab had gone to Supreme Court.
yes.
And finally, what the Supreme Court in that case did, it exercised the power of Article 142.
No, last para, you lordship applying the above principle in this instance case, it will be noticed that the trial court recorded a categorical finding of the fact that the proper opportunity of hearing was not afforded to the respondent in the departmental proceeding, and that his allegation that his signature on the certain papers during those proceedings was obtained under duress was not controverted, as the state of Punjab has.
That different.
Yes. No, only that unauthorized period that has been regularized as EOL, so that doesn't mean there is no misconduct. And my
All right, they will deliver.
well,
Four weeks hence.
Item 42. Item 42, last occasion, my lord directed to deposited amount of 3 lakh some odd. We have already deposited shape of draft, and I have hand over to the put a direction given to hand over to my learned friend who have given. Against the order of the Learned Central Tribunal, the concerned petition also file a application before my lord, and we also department also file a, both are there. So required to file the affidavit. What I observed. So by 2 weeks you will file the affidavit, my lordship will take it.
Yes, my lord. Let him file the affidavit. And
They are also file affidavit, not only.
Subitem also I have to file an affidavit. In subitem, my lord, I have to file the affidavit. There are 2 items. My lord.
2 items. One is prepared by the Union of India, another is by this petition.
Where is Annexure 3 page?
Pardon?
Annexure 3?
Annexure 3 impugned order, my lord.
Here is the case, excess payment has been
Page
made to the
63, my lord. Page 63 of the brief. Operative person at page 66.
paragraph 9.
8 and 9 both.
Leave encashment.
Pardon? Yes, live in gas.
What happened, they are saying this, we have wrongly deducted or whatever may be, even though I have taken excess payment, but legally you are not entitled to deduct it. Their sole point before my lord is that even though I have taken excess payment, the department didn't have power to deduct it after my retirement because the law didn't provide. We are swinging our rules. This is the only case.
I had to take how and take.
No, my lord. Your lordship, I have retired. After 1 year of my retirement, they have sanctioned the yarn leave. And your lordship has knows that rule 39 sub rule 3, there cannot be any deduction of yarn leave subject to or without any disciplinary proceeding or criminal proceeding.
Where is that?
That is the rules, leave rules, CCS leave rules. May I permitted to read that? The authority competent to grant leave any may withhold whole or part of cash equivalent of yarn leave in case of government servant who retired from service on attaining the age of retirement while under suspension or while disciplinary or criminal proceeding are pending against him. If in view of such authority, there is a possibility of some money becoming recoverable from him on conclusion of the proceedings against him. On conclusion of the proceeding, he will become eligible to the amount so withheld after adjustment of the government dues, if any. If that's so, my lord, when I have retired on attaining the age of superannuation, they have given the certificate of no dues. After 1 year, the legitimate dues of that amount has been cut. The learned tribunal, your lordship may kindly see the paragraph 9 of the findings of the learned tribunal.
Where is
At
that-
page 66.
Where is that notice saying that after 1 year, the notice?
Yes, I have they have not issued any. Yes, I am coming. Kindly see the annexure what my learned friend has annexed.
Is this your clear case? And you admit that you had received more amount than what you are entitled to?
No. Part is I am entitled to, I have to receive. Part I am entitled to, I have to receive.
No, that's the thing. The petitioner himself admits that yes, I had received. So this is not admitted, Mr.
No, my lord. What is the case? They are saying that whatever the excess amount is been paid, after retirement, whatever calculation is coming, what he entitled to, we are deducting the same amount and paid to him. He is saying that no, we will not receive the deduction after
There
deduction.
are two things.
My lord.
One, according to you, he had received certain amount
Yes.
in excess to what he was entitled to.
Exactly.
This is your case.
Yes, ma'am.
Whether this fact is admitted by him or not.
He disputing that even though my retirement amount will such
Even though, forget rules.
He is not
now we
admitting.
will come later.
Yes, he is not admitting.
On facts, let us understand whether he admits this position or not, factual position or not.
He is not admitting.
He is not admitting. Therefore, the first dispute is as to whether any excess amount was paid to
paid or not. Yes.
And then the question is, then even if the excess amount was paid, in view of the rule which he is referring to, you are entitled to recover the amount or not.
Exactly.
These are two
things. Yes.
So
Also, right lordship got it. Yes.
How do you say that any amount in excess to his entitlement?
Well, the calculation we have given. We have given all the documents shows that in the time of before retirement, whatever amount taken, excess amount is taken, it was found on the subsequently, and he is entitled to get.
Just a minute.
Yes, ma'am.
Which rule?
My lord, rule 39 of
CCS leave rules.
ECS.
CCS, Central.
It must be in the fundamental rules or secondary rules.
Yeah, that is fundamental rules part 3.
Fundamental rules part, not in this. No. Fundamental rules. Fundamental. All right, we will take up the matter later. My book is not here. You can take up the matter tomorrow or a day after.
Next week, because
Next
tomorrow.
week, all right. As requested on behalf of the respondent, your opposite party.
Yes.
My lord,
One case I am the petitioner, another case he is the petitioner.
They all starting this matter on, these matters on 1 week. Fundamental rules for.
Item 43.
Lordship, I'm appearing on behalf of Mr. Acharya. I'll supplement the affidavit as your Lordship has said in the morning. I'll supplement the affidavit. Your Lordship may kindly call it on Thursday.
So what do you want?
I'll file the supplementary affidavit and your Lordship may kindly call the matter on Thursday.
As requested on behalf of the petitioner, list this matter on Thursday. So in the meanwhile, supplementary affidavit verifying the amendments made in the writ petition. Writ petition or was 41, item number
43.
43.
Your Lordship, interim order to continue.
Can be maybe filed. First of the interim order shall continue in the meanwhile.
Item 44.
Your Lordship, on item 44, on behalf of my learned senior, Mr. Palit, Your Lordship, some time may be granted to file a supplementary affidavit.
2 weeks. Let's start after 5 weeks.
Your Lordship.
It will come after 5 weeks.
Your Lordship,
Problem.
interim order to continue, Your Lordship.
Interim order is there.
Yes, Your Lordship. Ordered it.
Continue.
Item 45. Item number 45.
Senior is on staircase, my lord. Beg pardon, your lord, my senior is staircase. Kindly pass over.
Also, we
Yes,
can
yes, staircase, my lord, is here, there.
all right. We're waiting.
Lordship, in fact, that same problem affidavit we have not.
All right. When do you want?
Lordship, by next week we'll file.
Next week. 1 week. 3 weeks. It will come after 3 weeks.
Lordship, interim order there. Interim order there. Lordship.
Interim order. Interim order. For order one first. Shall continue in the meanwhile.
Item 46.
My lord, item 46, 47, both are infractions.
All right. You are happy.
Because it was challenging the order of transfer. In the meantime, it.
You have joined.
My lords, actually, what
All right,
has
whatever.
my lords,
I appear for opposite party numbers 2, 3, and 4, Food Corporation of India.
Learned counsel appearing on behalf of the petitioners. Petitioners, alag alag petitioner submits that this application has become infructuous. Stop. The application stands disposed of accordingly.
But I am appealing for OP number 1,
Please give your appearance.
in both the cases, ma'am.
For the cases. Separate order pass over 46 and 47.
Yes.
Item 48.
48 this matter is infructuous matter.
Yes.
Item 49.
Yes, madam. In this application, petitioner challenged inclusion of criteria in the tender conditions, which is contrary to the registration rules 1967. The last shall look to he challenged the inclusion of criteria in the tender document, which is contrary to registration rules contracts registration rules 1967. The last shall look to the tender call notice or annexed 2.
Oh, when was the tender issued?
The tender was issued in 2021.
So we are in 2024.
Yes, madam. But I am not praying that that work, but that is the conditions which is in subsequently.
But whether it will serve any purpose, tender must have been finalized. Work must have
that has been finalized or not, that is not within my knowledge, because they have filed an application, an interim application before this honorable court, seeking liberty to allow them to finalize the tender. That application
that must be in 2021.
No, that is in 2020. That application was 2022, my lord. That order, no order has been passed in this application. But
And one more thing, Lord, he participated in the tender, found ineligible. Thereafter, he challenged the conditions incorporated in the tender call notice. How can he do that, Lord? Once participating in the tender, he cannot challenge the tender.
Is right in his submission.
And it's also academic. My friend, if he insists upon, after 3 years, it has become academic only, Lord.
Because, my lord,
we will decide that issue, but some other proceeding.
Right.
But in all occasions, that situation arose because when that has been challenged, and
such matters should be decided expeditiously. So next time, ensure that the moment they come out with such condition in the tender notice, come to the court, get the dispute decided, issue decided. All right. The tender process, which is the subject matter of the present proceeding, had begun in 2021. The top. The petitioner is questioning the legality of one of the conditions in the tender notice. The top. London Council representing the state of Orissa has rightly pointed out that after having participated in the tender process, the petitioner ought not to have questioned. Petitioner was stopped from questioning the legality of the conditions prescribed in the tender notice. He has also submitted that the dispute which is being raised in the present writ petition by the petitioner has now become only academic and does not require adjudication. Next, we find force in the submissions advanced on behalf of the state of this application stands dismissed accordingly.
Item 50.
May I please your lordship? Your lordship, I am appearing on behalf of Mr. Prabhu Chandra Naik. 2 weeks time may be given to file rejoinder.
First you file affidavit, then rejoinder.
As your lordship, please.
Affidavit and rejoinder both cover. Yes.
Okay.
2 weeks. List 5 weeks.
Item 51. Item number 51.
One appears on behalf of the petitioner. List this matter on 4 weeks, 5 weeks.
Item 52.
May I please your lordship, my lord? This matter relates to a refund of COVID fee which has been paid in excess to the state government. A batch of cases have been filed, and the last occasion, the other court, my lord, has directed all the cases to be listed today, but only 2 cases have come. Other batch case has not come, so if your lordship direct the other connected cases, they have given the list. All the cases may be taken up together.
Where is that order?
In the your lordship may see 15/9/23. 15/9/23.
In this case.
It's no bicy.
Only one, it was directed to be listed with. So, which connected matters? How many matters are there?
And just pick your author जो case उड़ा कुछ pick your author जो batch टा देख रहा है list
देखिए तो हमारे कुछ
कमेंट पर जमा काउंटर भी मतलब
we'll file the list file. We'll file the list file. Pending list.
It is stated at the bar that there are number of writ petitions pending involving same issue which is involved in the present case. Stop. Learned counsel representing the state submits that he shall be furnishing a list of such cases by
Thursday morning.
By Thursday, so as to facilitate hearing of all such cases together. Stop. List this matter on Monday.
Next Monday. And one more thing, my lord. In my case, that is the second item of this item 52. State government has filed the counter and I have filed the rejoinder. That case is ready. And state government submits before this honorable court that they will adopt this counter in all these cases. So the honorable court directed the state government to sort the copy of this counter on other councils, but they have not sought.
It's a question of
let them there.
There are two things. We had to adjudicate upon the admitted position. There is no dispute on facts. One counter affidavit is there, you must be having a copy of that.
I have got that.
Unofficially.
No, not unofficially. I have got officially.
Then
I have filed the rejoinder also.
And why should you have?
Other friends are there, my lord. That
Give
is
them. Give them.
First case means. First case is not file counter.
And it's a matter of policy decision. You should take a policy decision. The state should take a policy decision. Instead of court deciding such matters, when the things are admitted, the nature of the kind of sufferings which everyone had to undergo in that period. So taking all those facts, you should have taken a policy decision.
My lord, I think not in other cases, my lord, counter affidavit has been adopted, my lord. I'll take care, my lord, whether this case.
All right. Monday,
19th.
19.
From 53.
Your lordship, 2 weeks time for filing supplementary affidavit.
2 weeks, 4 weeks.
Well,
within 2 weeks file, or
You
5 weeks, 4 or 5. So many cases are coming on after 4 weeks, therefore 5 weeks.
Item 54.
May I please, your lordship. Here the petitioners are the substaffs. They are the sweeper cum messengers of the Grameen Bank. While they are continuing since 96 onwards, all of a sudden they have, without making any regularization or granting the EPF benefits, they have issued Annex 2. Kind of a glance to page 29. 29 is the tender call notice. For page 29, my lord, Annex 2.
You could have raised the industrial dispute. Why have you come here?
My lord, they have issued this tender call notice. Tender call notice by replacing these persons by way of outsourcing. For that, I came to the rescue of my lords, and my lords are interimly protected by the order dated.
You are working as what in the Grameen Bank?
Sweeper cum messenger.
Regular employee?
My lord, no,
Not regular.
no.
Under whom?
Under the branch manager of the concerned branch since 96 onwards.
Until you don't have remedy under the idea?
My lord, idea so far they have replaced me. They want to replace me. As of date, I am continuing. By virtue of the protection of this honorable court on 27/5/2022, can have a glance to the order.
You move for abolishing this as contract labor.
My lord,
Won't
since-
be appropriate authority.
But I may be protected, my lord, till then, because during pendency of this writ application and the interim order when it is operating, since 3 days back, they are not allowing me to discharge my duty. 10 persons from different
If
branches.
there is cessation of employment, you apply.
My lord, can they, now they are adopting one method by replacing the ad hoc employees, contractual.
Is there any law under which an employer can be stopped from asking for contract labor unless the contract labor is abolished?
My lord, we are discharging our duty.
Under which provision you will seek interference?
My lord, I have been protected by my lords.
Protected. So counsel, that is the question. What is your legal right?
My lord, it is a reasonable expectation, certainly.
Reasonable expectation is not a legal right.
My lord, because since 96, we are the poor employees working as messenger cum sweeper and getting a paltry amount of salary.
So you want an answer? There are many poor persons who have not got this even for more than 40 years. So was there any process followed for your no? So there are crores of people dying.
Well, that is true. But at the same time,
Yes.
I have been saved.
You
I am
have saved under an order.
making my livelihood by engaging myself since 96 because
You approached them. Did you approach the bank?
yes, ma'am.
Where?
But to the concerned branch and the authority chairman of the Grameen Bank.
When did you do?
And by this process, I have approached by filing the representations also in person through the union also. I have exposed our.
Then you are through union. So your union has taken up your matter.
No, but individually they have
Individually?
not allowing us
Yes.
to discharge our duty because since 96 onwards we are continuing. My learned friend is for the.
All that will happen is the bank manager will be replaced by the contractor. You will do the work.
But they are not allowing us. They want to replace it by the outsourcing persons, ignoring our long-standing service.
Supply you only to do the work.
That is, they are not doing, my lord.
Well, let's see here the
That is
question.
what you want.
No, we want that we should continue and to.
You have been there for last 36 years according to you.
No, my lord, 25 years.
25 years. And do they admit?
Well, let's see here the question is, my lords.
Do they admit?
Yes, my lord. We are continuing as usual.
But for regularization of their service, they have raised their voice before the labor court, my lord.
They have already gone.
Yes, my lord. That is
Why are you pursuing your remedy here?
here, my lord, the policy
Now,
decision of the my
when
lord,
the
the policy
matrix
decision.
session of this honorable court.
Mr. Counsel, have you gone to the labor court or the authorities?
Yes, my lord.
Have you stated?
No, I have gone for
Suppression,
other
my lord.
purpose, my lord, not for regularization.
For regularization.
Then you can, the plea which you are taking here, you can take there also.
Till then, my lord, I may be
Where is the
protected.
question of till then?
My lord, we have gone for other purpose. So far, the minimum wages is concerned.
Minimum wages. He is saying regulation, you are saying minimum wages.
No, no. So far, this labor court is concerned, the authority, that we have raised the dispute for the purpose of they are not paying the minimum.
Mr. Counsel, either you are refusing to understand or you are not, or you are just misleading us.
Here is
Only because some interim order is there, therefore there is a law.
No,
You have approached the authority for regularization, then you are saying no for minimum wages.
Though we are getting, my humble submission would be.
I may. It is the policy decision of the government to make the outsource, my lords. Only to implement that policy decision of the government, my lords, the bank authority has.
You have filed your affidavit.
Yes, my lords.
So you want your matter to be decided by us. We will do that.
No, my lord.
As you wish.
1 week after later.
Counter, everything is ready? Pleadings are ready?
My lord.
Yes.
We will file the rejoinder. They have filed the counter. They have served the copy. We will file the rejoinder.
Rejoinder, they have taken 4 times, my lords, your lords.
Rejoinder.
Well,
1 week.
We won't grant.
1 week.
When was the counter affidavit filed?
Counter approved file, my lords, since long.
It was filed on 9th, 8 or something. 16th of August, Ashton.
And similar set of, my lord, sir, similar
Okay.
set of person also.
Will not do that.
May I
Make your
pre-
submissions,
may I-
take an order.
May I pray for a week time?
No, sorry. Sorry. Make your submission, please. Because the only thing which you are having as on date is an interim order from this court.
And the long experience and continuing
Yes,
as.
we are ready to hear. To address us.
May I take 1 week time
What?
to substantiate with the instruction to file the rejoinder?
Substantiate to file rejoinder to what?
My grounds of.
Yes, the counter affidavit was filed in 2022. We are in 2024.
As a last chance.
No last chance. Where is the question of last chance? Unnecessary. The matter is necessarily pending here. And in fact, you are doing disservice to these persons.
Any provision of law you can show
Also.
that will prevent an employer from seeking outsourcing.
Well, exactly not outsourcing, but so far the replacement is concerned.
You can show that the labor is contract labor is banned. About that notification. is
So
not
far
there.
the replacement is concerned of the contract employee, so far the parassing decision is concerned. So one set of contractual employee cannot replace the another set of.
That is a different aspect altogether. They are not doing that. They are employers. They also have some choice to have employees of work, their work done.
No, that is true.
Yes.
But at the same time, my humble submission will be after continuing for a prolonged period, when we are discharging the duty of the sweeper cum messenger and we are discharging with the utmost satisfaction of the authority, now they are coming that we should be replaced by the outsourcing, ignoring our continuous and relentless effort of service for more than 2 decades. And that happened in the meantime also we have lost and become overaged. So far this age part is concerned, we may not get employment elsewhere. And that is the source of our livelihood.
All right. That's all.
You have referred to the government policy.
My lord.
Have you
Yes, my
referred
lord.
to it? Where is the policy document?
My lord, policy that annexer A.
Page.
Annexer A at page 14, my lord, in my counter, my lord.
Page 14.
14 page, you will not be relevant, para my lords, you will not be kind of a glance, page 19.
Can do if they seek in our liberty, they will leave. We cannot compel them. We cannot compel them to approve.
Two weeks. You approach the appropriate government who's taken out this policy. 2 weeks you will get.
Hey.
The commissioners. The benefit application had to challenge an order of surrender. And then also challenge tender notice. It's by 2022 for outsourcing of the sweeping sweepers.
Sweeping, cleaning and maintenance. In non-core.
Tender notice for providing personnel for engagement on daily basis in the branches of Mumbai Grameen Bank. The petitioners claim that at present they are engaged as keepers in various branches.
Different branches.
Various branches of the state bank. And their interest shall be widely adversely affected if the engagement of people is done through outsourcing. So, next, a counter affidavit has been filed on behalf of the bank. So, it is the state of the bank that it is the stand of the bank that the said tender notice is in consonance with the policy decision taken by the National Bank of Agriculture and Rural Development, which is the what do you call parent body or what?
Yes.
This is your
Subsidiary.
No, this is not your subsidiary. You are the subsidiary of this.
My lords. The bank. Nobody is the parental. My lords. Parent body. My lords.
May not be parent body. This is now lecture. On behalf of the petitioners, whom I delight of the time taken on behalf of the bank seeks permission to withdraw his reputation with regard to approach the chief general manager NABARD by making a representation against the policy decision, against the same policy decision of the bank and the adverse consequences of such policy affecting so work in various branches of the bank for more than 2 decades. This application is review of the total submission made on behalf of the petitioners. This application is disposed of with the liberty to the petitioner to file petitioners to file a representation before so and so Before NABARD.
But NABARD is not party in this case. NABARD
Chief General Manager.
is not made party to the NABARD matters. Yeah.
Chief General Manager of the sponsoring bank, because normally Grameen banks are, that is known as sponsoring bank.
General Manager. NABARD. In 2 weeks from today. We are conscious of the fact that NABARD is not a party in the. So we are respect that the competent authority of NABARD shall consider the petitioner's representation and takes the decision in accordance with law as expeditiously as possible. So, the petitioners have been protected by an interim order. What is the name?
27/5 to 2022.
The interim order shall continue for 2 months from today. We have to clear that we have not gone into the legality of the conversation about NABARD. The right of the petitioners to continue on the regular basis, then the various branches of
Obliged.
Item 55.
In this case, my lord, my counter is ready. Grant some time to file counter.
How much time?
My lord, 1 week time.
Your Lordship, in the meantime, we'll file the supplementary affidavit. Yes, Your Lordship.
Stated by the current council, we state that we have been filing a particular activity within a week. On 3 weeks. The council for the petitioner may avail, may file a rejoinder to the counter affidavit. If so required.
Obliged. Item 56.
Item 56 में की 2 weeks time to file a supplementary affidavit, my lord. No, but the counter has also not been filed, my lord. Counter is interim order to continue. Interim order is there. Obliged.
57.
My lord, in item 57, my lord, 3 weeks time to file rejoinder, and in the meantime, I will also file the supplementary affidavit.
Yes.
Item 58.
May I please, Your Lordship?
I am for the respondent, and on the previous occasion, government had filed the affidavit. So, Your Lordship, I need 2 weeks time to file reply to it. Pardon, Your Lordship?
File a supplementary affidavit also.
Yes, Your Lordship.
Well, supplementary affidavits you will not, because it's a writ appeal.
Writ appeal.
Well, please know the respondent.
From 59.
59 supplementary affidavit is required to be filed 2 weeks.
Sorry.
No, my lord, done. Interim order is there, Your Lordship.
Item 60.
Interim order is there, madam. 59.
Okay.
My lords, I'll file a supplementary affidavit, my lords. Next week, by next week, I'll file it. Interim order may continue. Deeply obliged. Interim order may continue. Obliged.
61.
61, my lord, on behalf of Mr. Pandey, my lord, is admitted in hospital, my lord. Mr. Pandey, the council, my lord, is admitted in hospital, my lord. Your lordship can take up one chapter.
What has happened? What has happened? Why didn't they?
Yes,
No, his son has been admitted. His son has been admitted in hospital.
Yes, sir.
There was meeting morning that-
My lord, my lord. Item 11.
Item number
61.
What has happened to his son?
Son, but a piles operation and another major operation inside the
Yes.
obliged.
62.
My lord, pursuant to the order dated 18/8/2023, passed in writ appeal number 1421/2023, your lordship is to consider for passing the interim order, my lord. Interim application for interim order. Here, my lord, a rule has been framed under Annexure 5 by the Register of Cooperative Societies exercising the power under section 33A of the Orissa Cooperative Society Act, my lord.
Cooperative Societies Act, local.
I have challenged that it is the
You have challenged this order.
rule.
Rule.
Yes, my lord.
No, this is a writ petition or appeal.
It's the writ petition, my lord.
Please come to order number 1.
Yes, my lord. Order number 1, my lord. Notice has been issued by the Sonor Court.
Oh,
and
sorry, then I am seeing some. This is WPC 17604.
WC 17604, my lord.
Yes.
Yes.
Please come to the first order.
Order is, my lord.
18/8/2023.
23, my lord.
Come to paragraph 3.
Lord Council of State accepts notice.
Paragraph 3, 18/8.
18/8. Yes, my lord. That is passed in the writ appeal, my lord, 18/8. Paragraph, this intra-court appeal has been filed to challenge the interim order dated 35/2023, delivered in IN number 081 of 2023 by the said order. Lawrence Single Judge has observed as follows. As an interim measure, it is directed that any decision taken pursuant to the impugned order by the Annexure 5 shall abide by the result of the writ petition. I challenge that in the writ appeal. On a widest scrutiny, we find that by the writ petition being WPC number so and so, the appellant has challenged the common cadre of chief executive officers, facts.
No, why? All right, let us
And this order, this 18/8/2023 order has been passed in writ appeal.
Writ appeal, my lord. Writ appeal number 1421 of 2023.
So where is that matter presently listed or not?
It has not, it was disposed of, my lord.
All right.
With the observation for consideration of interim order, my lord. This rule I challenge basically that the power exercised by the Orissa Cooperative Society, Register of Cooperative Societies, my lord, under Annexure 5, my lord, by exercising under section 33B, your lordship can come to page 39, my lord.
Page 39.
Yes, my lord, it petition. In exercise of the powers, do you also get, my lord, that? Page 39.
Yes, please.
In exercise of powers conferred upon me under section 33B of the Orissa Cooperative Societies Act 1962, I, Sri Uddhav Chandra Maji, IAS, Register of the Cooperative Society, Odisha, to do hereby prescribe the rules called the Common Cadre of the Chief Executive Officers, PACs, SCS, LAMPs, and FSC rules 2023 and enclosed herewith, my lord. This provision 33B has been repealed from the Act, my lord, on by the Odisha Act 11 of 2004, my lord. You will also kindly see this. That power does not vest with the register to frame the rule, my lord. On that ground, I am challenging this rule. Then please give this.
It is repealed.
Pardon?
33B is repealed.
Repealed, my lord.
The 24 edition carries the rule section.
24 edition of the book, my lord.
Carries the.
I have given that, you will also kindly see. The latest book I have also brought, that is also latest book says that it has been repealed, my lord.
Who says?
But
so where is the notification repealing the
that has been stated in the books itself, my lord. In the book Property Act, my lord.
No, do you have the gazette notification?
No, I have not with
you cannot rely on this.
I will bring that gazette notification also. I will bring that gazette notification.
When was it repealed?
It was as per the Act 4 of 11 of 2004. It has been repealed.
Let us see.
Amended. Not repealed.
Pardon?
Amended. The entire section stands amended by.
Even by the publication, my lord, latest publication of the Cooperative Act, that is in the year 2022, that rule was not, that act is not, that section 33B is not there also in that. That's a 22 book. That 22 publication.
Difficulty is that these books cannot govern the High Court.
Okay, I will produce, my lord. That I will produce. I will find out from your lordship's library and I will produce it.
It is not there.
B is not there. Two publishers, my lord. That is Orissa Law Review publisher. That is another publisher, Legal Miscellaneous. Two publishers are published. I will produce my gazette. You will also keep it
Get for us Act 11.
Pardon, my lord?
Get us the amending it.
Yes, my lord. That I will bring
Act
that.
11.
Yes, my lord.
So what was amended? Whether it was repealed or it was substituted? We shall know from the amended act.
Yes,
Amended by Orissa Act number 11.
11.
2004.
Yes, I will find out.
In that section 21.
It will not be, it is only available, your lordship.
So why are you not relying on this and you are relying on that?
Two books I have relied, my lord. Two books. One is published by Orissa Law Review Publication. Another is the Legal Miscellaneous.
This is not available in the.
Must be available
Only it
online.
can be available in the, only your lordship's judge's
Act
library.
11. Act 11 of Odisha, Act 11 of 2004. And it must be there in the journals, your
Local journals.
local
Act
journal.
number 11. ACT. Then
No,
number.
that is not available. I checked up, is available. I'll find it to your lordship's judge's library. I will try to get it, my lord. Your lordship keep it next week, I will produce that.
Let us try. Nee, all right. All right.
What is Odisha Act 11? Consolidation of, section 21? Let's see section 21.
No, this is something else.
Oh.
This is something else. This is of 2013. We are concerned with 2004. Act 11 of 2004.
ORISSA.
11. Act 11 of 2004, not of 12. Please. It is as requested on behalf
Next
of
week, my lord, I'll get it.
Krishna list this matter on next Tuesday. So as to enable him to bring on record the Gazette notification of the Odisha Act 11
Act 11 of 2004.
of 2004. Introducing amendment in section 33, capital B of the Odisha Cooperative Societies Act 1962.
From 63. Lordship keep it next week.
Next Tuesday. Next Tuesday.
63 minutes on this case, minutes. On the last occasion, the lordship have directed the state to file their counter as a last chance, minutes. In several occasions, they have taken time but not filed the counter, minutes.
Ransom time.
Last. Second last chance.
No.
Third last chance.
63 item.
Yes.
My senior was making submission on item 64. Item 63, my lord, we have already received the Paravai's comments. My lord, may I kindly grant us. We have already received, my lord, the Paravai's comments.
But last chance is over.
Second last, third last.
My lord, in the meantime, he should come up with a supplementary affidavit. I will file it.
2 weeks time is allowed for the petitioner to file a supplementary affidavit duly verifying the pleading in the writ petition in accordance with so and so. It will be open for the state to avail the time to comply with the court's earlier orders, whereby it was directed to file counter affidavit.
Item 64.
Your Lordship, item 64, Your Lordship, 1 week time to file
1
supplementary.
week, 2 weeks, 3 weeks. Sir. 1 week for supplementary, or is 3 weeks?
Item 65.
Obliged. Your Lordship, item 65, I have not been served with the copy.
Well, already counter has been filed by mail by the system, and hard copy we have. But I am serving a copy to my sister, and after affidavit we will file the hard copy to the court. Plus we give on time. We are ready with this copy, but after system will change, we will file the affidavit and send.
Your Lordship, thereafter 2 weeks time may be given to me for filing of rejoinder, Your Lordship.
We already served the copy. Just now we served the copy.
And a Deputy Solicitor General representing the Union of India. You are Union of India. You represent Union of India.
Yes, my lord.
Union of India has submitted that a counter affidavit has been filed online. Hard copy of which has been served upon learned counsel for the petitioner in the court itself.
Yes, ma'am.
So, learned counsel for the petitioner has found time for filing a rejoinder to the said counter affidavit, if so required. So, let this case on 3 weeks. So, in the meanwhile, learned counsel for the petitioner may file a supplementary affidavit verifying the readings in the written petition in accordance with this one.
Item
conformity with
Obliged.
requirement and yes.
Item 66.
Yes, my lord, in this case, I need to file the improved affidavit, my lord. Kindly grant me 3 weeks time, my lord. My lord, in the meantime, I need to file rejoinder and interim order dated 4/10/23 may be continued.
67.
67, my lord, it's also same, my lord. I need to file the improved affidavit, my lord.
All.
3 weeks time
Only.
only.
No rejoinder, nothing.
Rejoinder
No,
already
it's
filed. Grateful.
Item 68.
Item 68, my lord. 68, my lord. I'm filing the new format affidavit, my lord.
My lord, I pray for
my lord,
time to
just
file
I
counter.
need-
It is
my lord,
ready, my lord.
My lord, let me.
My lord, I had on the last occasion short time for filing a counter affidavit, though it is ready, my lord, it has to be sworn to, my lord. I ask for a week's time, my lord, to file.
My lord, what is the urgency in this case, my lord? That's what I am praying, my lord. My lord, after 10 years, my lord, they have imposed a penalty. And as per the agreement, my lord, the clause says that within 3 months, they have to impose the penalty. Now, after 10 years, they are imposing the penalty, my lord. If they file a counter, I'm only seeking for an
Penalty under what?
My lord, sorry.
Penalty under what?
Penalty, my lord, contractual matter, my lord. Because contract was over by 2013, my lord. Thereafter, my lord, for 10 years, my lord, they didn't close the contract. And after 10 years, they have given me a 12 lakhs penalty on me, my lord, without any so-cause.
May I only submit, my lord, it was pending, it could not be finalized because of the conduct of the petitioner, my lord. He had carried the writ application challenging the tender condition before this honorable court. It was pending from 2012 to 18. I'm sorry, it was disposed on of 19. My lord, what I pray, my lord, in the meantime, 4 months have elapsed when the order was passed. Maybe in the meantime, there would have been recovery. What I was praying, my lord, I will bring that before this.
Difficulty is that I have 2 ears but one brain.
I'm sorry.
Both of you
shouldn't have. I'm sorry, my lord. I stand corrected, my lord. I shouldn't have.
Yes.
Yes, my lord. My lord, my humble submission is that I'm only seeking an interim protection till they file the counter affidavit, because meantime, my lord, I am not working on that project anymore. It has been completed. It was a 1-year project, my lord. It has been completed. Now, my lord, after 10 years, when they are imposing this penalty, this, my lord, without any so cause, without any procedure, without following the due process of law, that is principles of natural justice, has been violated in this case. My lord, I am only seeking that interim, my lord, let it be protected. I may be protected till that period.
What are they going to do?
They are going to recover from my running account, my lord, because I am doing other projects in similar work, my lord, similar work in different project, my lord. Under MCL, I am doing different works, so they may recover it from the different project.
Is there any arbitration clause?
Arbitration clause, my lord, there is a resolution clause, clause 12, my lord.
My lord, they have not.
Please.
I'm sorry. I'm
This
very
is
sorry.
not the
I'm
way.
sorry. I'm very sorry, my lord. I'm sorry. My lord, I shouldn't have. I'm very sorry. My lord.
Yes.
Yes, my lord. This is 12, page 71, my lord. Clause 12, settlement of dispute. May I just read it out? It is incumbent upon the contractor to avoid litigation dispute arising during the course of execution. However, if the dispute takes place between the contractor and the department, efforts shall be made to first settle the dispute at the company level. The contractor should make a request in writing to the engineer in charge for settlement of such dispute within 30 days or arising out of the cause of dispute claim, failing which no dispute claims of the contractor shall be entertained by the company. If
So when was the you are calling it penalty? When was that imposed?
by that penalty has been imposed on annexure 1, my lord, impugned order. That is the impugned, my lord. 12/11/2023, my lord. After, my lord, when the work was complete, my lord, kindly see the agreement.
You should have immediately gone to him.
Because that is, my lord, that is, if clause 12 will be read at its proper space, my lord, it is during the execution of the work, my lord. The line says it is during the execution of the work.
Sorry, let me see. You might be correct.
My
No.
Number 68.
71, 71, 12.
Page?
12, page 71, my lord.
Just a minute. Annexure?
Annexure, my lord. 3, my lord. Annexure 3.
Yes. 12. Clause 12.
Yes, my lord. Yes, my lord. It is incumbent upon the contractor to avoid litigation and dispute during the course of execution, my lord.
And there is no other provision.
No, my lord, there is no other dispute settlement clause. Now they, in present, in today's contract, my lord, they have included an arbitration clause, but in previous contract, there was no arbitration clause.
Yes, now.
My lord, may I take your lordship to the impugned order itself? At page 13, the order itself reads total amount of 12,44,000 should be recovered from the contractor. The amount of 328 is available in lieu of cash retention money. So, my lord, a part of the order has already been worked out. So there has already been recovery. This is a PSU, my lord.
No, his grievance is that you have imposed penalty.
My lord.
Without giving him any opportunity to explain.
My lord.
Whether this is an admitted fact or not.
No, my lord. In my counter, what I have, because it is already ready, my lord. We have already given him, because there is a hindrance register which is.
You have filed your counter affidavit. you give us an undertaking that till the matter is taken up, you will not take steps to recover.
If it is not recovered, my lord, I can undertake, my lord.
All right,
My lord,
all right.
my lord.
Which order is impugned?
My lord,
Annexure 1.
Annexure 1.
The petitioner in the present writ application has challenged later dated 12/1/2023.
12/11. Yes.
2023, whereby penalty of how much
12,44,316.70
has been imposed in connection with an agreement in relation to an agreement of
My lord, agreement is at page 16, 7/8/2012.
agreement regarding what?
My lord, it is transportation of crushed coal by trippers and
Agreement relating to transportation
transportation of coal, my
of
coal.
coal.
Yes.
Full stop. It is the specific case of the petitioner that the work was executed in the year.
In the year 2013, it was completed, my lord.
In
It
the
was
year
for one.
2013 itself, and the impugned order has been passed. Impugned decision has been taken without giving him an opportunity of hearing, giving the petitioner an opportunity of hearing. I'll stop. Referring to the dispute settlement clause under the agreement clause, that is clause 12 of the agreement, London Council for the petitioner has submitted that the agreement does not provide for, agreement does not contain any arbitration clause, and there is no provision other than clause 12 for settlement of disputes. First stop. Next, London Council representing, you are representing whom?
MCL, my lord.
Mahanadi Coalfields has submitted that part of the impugned order has already been implemented in as much as some amount you have recovered.
My lord, the order itself says we have recovered.
The retention money. Retention. They have retained that money.
By
Retention amount?
Huh?
Retention money was withheld.
By appropriating the retention money. Stop. Stop. He seeks time to file a counter affidavit. Stop. List this matter on how much time?
A week's time will suffice.
A week. Filing. List this matter on 2 weeks. Stop. In the meanwhile, the counter affidavit must be filed. Stop. Till further orders, the respondents are restrained from making any recovery from the petitioner's account pursuant to the impugned order.
If not already done, my lord.
Comma, if further, we have said further.
3 lakhs have been already recovered. 9
Sir,
lakhs.
Counsel, there
I'm
we are
sorry,
saying
my lord.
further.
There, my lord. My
Bolo, what has?
Sir, till further orders, the restaurants are restrained from making any recovery.
Making further recovery. Making
Further
any
recovery from the petitioners.
Correct?
My lord.
Personal to the employer.
Obliged.
Much obliged.
You can say, you will like it.
69.
May I please, your lordship? Here the affidavit was not in proper format. I'm just filing an additional. That be taken on record.
Good. That you are not taking time, rather filing it. Let me see what have you filed.
Lord, in this writ application, I am challenging the order of cancellation of tender after the petitioner having been declared as the L1 bidder, my lord. Page 80, annexes.
Don't have any right, Mr.
Yes, my lord. I don't have any vested right, and the scope of interference is very limited. But my lord, I will try to demonstrate that it's completely arbitrary and unfair, my lord, on the face of it. My lord, may turn to page 80.
Sorry.
My lord.
Sorry.
My lord, it's on the face of it, is it arbitrary and unfair?
Face of when it comes to a contract.
My lord.
Not wholly, but even the estate behaves like a private person.
Yes, my lord.
So the state has to decide whether the work is to be executed,
Yes, my lord.
not to be executed. So we cannot compel the writ court cannot compel that. See, you had advertised, you had issued the tender notice, therefore you get the work done.
But
and that too through L1.
But the procedure that the state has given to themselves, that we will be guided by this procedure, that they have not followed that procedure, which they have given unto themselves.
No, in any case, now since the tender notice itself has been cancelled, then
Yes,
nothing
ma'am.
remains.
No, my lord, I don't claim a vested right, but if I can show, my lord, that on the face of it is arbitrary, then I believe, my lord, your lordship can interfere. I am supported by some.
Interfere, he can interfere, he can do anything. The question is, what can we do? What kind of orders are we passing? What order? Write an order. Write an order in your favor.
I am.
Cannot. It happens. Why has this happened?
My lord, my lord, the chief construction engineer has no power, my lord, to decide, my lord, because he has to send the chief engineer, my lord, because it exceeds the more than 10 crores, my lord. So once the exceeds, my lord, 10 crore, my lord, thereafter the committee decided that to cancel this bid, my lord.
Something else? Come to page 80.
My lord. My lord, he has wrongly opened that financial bid, my lord. He has wrongly opened that financial bid, my lord. He has to wait the decision of the technical evaluation committee, my lord. Without outing, my lord, he opened this financial bid.
That is required.
My lord, may I submit one line to what my learned senior has? My lord, may I reply to one line just what my learned senior has submitted? That the chief construction engineer has taken the decision, although the chief engineer is the appropriate authority.
That is.
But here, my lord,
Come to annexure 6. This is the order you are challenging?
Yes.
Now, what is wrong in that order?
Yes, my lord. My lord, what my learned senior submitted, it's not true that the.
Forget his submission.
Yes, my lord.
Come to annexure 6.
Yes, my lord.
What is wrong in your?
The committee went through the memorandum, technical bids and price bids of all the qualified bidders. The committee observed that the chief construction engineer has opened the financial bids before technical evaluation at EIC level without following the statutory tender procedure, my lord. First, may I ask to, my lord, the question is, where is that tender, my lord, that tender procedure, which says that the chief construction engineer has to get the approval?
No, forget the procedure is that first of all,
no such procedure laid down anywhere in, my lord, they have not brought it on counter also.
Everywhere. Without opening technical bid, financial bid cannot be opened.
Yes, my lord. Now that's the point, my lord. Here it's a case. Technical bids were opened, scrutinized. I found qualified. Thereafter, the chief construction.
So, why is this?
That's the wrong, my lord. Exactly, that is what I am pointing at, my lord. It's a, my lord. This on the face of it, it is wrong, because it's the fact remains here is the chief construction engineer has invited the tender. Bids were submitted. After evaluating the technical bids of all the bidders, he published.
So where have you mentioned? Where have you stated? Where is your pleading?
Yes, madam. Let me kindly turn to.
Which paragraph?
Paragraph 4, my lord, may kindly see. The petitioner, along with OP number 5 and 6, have submitted their bids pursuant to the tender call notice. The technical bids were opened on the scheduled date and time. As per the technical bid evaluation summary uploaded in the e-tender portal, all the 3 bidders, including the petitioner and OP 5 and 6, have been qualified. Next, that paragraph 5. In terms of the tender call notice, the price bids submitted by the 3 technical qualified bidders were opened on 22/9/2023. As per the price bid opening summary, the petitioner having quoted 6.230% less.
When was this open technical bid?
My lord, and that's I have annexed at page 73, annexer 2. It was uploaded in the web portal on 16/9/2023.
16/9/2023. Yes.
And
So
now
why is this?
And now everything has been sent to the chief engineer. He will have to take the final decision. That's pending. At this stage they cancel.
Kindly see my Parvaz reply, my lord, my counter affidavit, my lord. Paragraph.
You file your affidavit, counter affidavit.
My lord, I have filed my counter affidavit.
You have filed?
I have filed my counter affidavit.
All right. So how do you justify this observation in
my lord,
page 70?
My lord, lordship, kindly see. There are the chief construction engineer invited 29 works, my lord. Out of 28 works, my lord, below 10 lakhs, 10 crore, my lord. And my lord.
Okay, please come to the reason assigned in the order.
My lord. The committee observed that CC has opened the financial bid, my lord, before technical evaluation at EIS level without following the statutory tender procedure, my lord. Hence, the committee unanimously opened to cancel the tender and instructed you to invite.
This is the reason.
My lord, but because, my lord, the CC has no power to open without outing the financial technical evaluation, my lord, he has wrongly opened the financial bid. That the reason, my lord, I have stated in my counter affidavit at paragraph 5, my lord, internal page 2, my lord. Let's see, kindly see page, internal page 3, my lord.
What is CCE?
CC, my lord, chief construction engineer.
Chief construction engineer.
My lord.
So he says that he had opened the financial bids.
My lord.
before technical evaluation
My lord, my lord.
EIC.
My lord, he has no power to open financial bid, my lord.
Huh?
My lord, when the amount estimated cost is more than 10 crores, my lord, the technical evaluation committee is the appropriate authority, my lord. He has wrongly opened the financial bid.
No, but technical evaluation of EIC was not done.
No, my lord. Before that, he has opened my financial bid.
No, but he is showing when was the technical bid opened.
Technical bid opened by the chief construction engineer, my lord. He has inadvertently opened that financial bid. He has no power to open that bid, my lord. When the estimated cost is crossed more than the 10 crores, my lord. And in the here, my lord, the estimated cost is more than 10 crores.
Different.
That he had no power to open financial.
The order itself.
My lord.
That he did not have the jurisdiction.
My lord. I have not mentioned, my lord. In reason
Right. We will not interfere with the order.
My lord.
If you take action against him. Otherwise, we may make observations against your chief engineer roads. Someone did something so bad that a bid had to be cancelled, and you are not taking any action against him.
No, my lord, he has no idea, my lord. He inadvertently, my lord, because he has invited 29 bids, my lord.
You have defense also for him.
Inadvertently, my lord, he has
This
done.
inadvertence can happen every time.
No, my lord.
So at least censor him. Minor penalty. Proceed against him. Seek instructions.
My lord.
Seek instructions. We may not grant the relief which he is seeking, but we may pass certain orders. Right. Because the submission which you are making
My lord.
is not there in the order.
My lord, that's.
And your submissions cannot improve the contents of the order.
My lord. Lordship, otherwise, your lordship may dispose of, my lord. In future, he will not do this. Lordship may dispose of this, my lord. In future, he will not do, my lord.
Oh, no. Seek instruction.
You withdraw impugn letter. You
Man.
give him the relief.
My
No, you should not.
I'll take
do
instruction.
that.
I'll take instruction.
Huh?
I'll take instruction.
You seek instructions.
My lord.
You do whatever.
My lord.
You can modify it. And we don't know.
My lord.
As requested on behalf of the state, in order to justify the reasons assigned in the impugned communication dated 5/12/2023 bracketed in Annexure 6, list this matter on 2 weeks.
Item 70.
Let's 69. There is a connected case. Sorry for interrupting. Item 69. No, there is a connected case, my lord.
69, 2 cases are.
Yes, Lord, sir. Here, my case, my lord, after negotiation, the tender committee accepted my bids, recommended for approval of formal approval of the government, my lord. And this, they have with one line, they have rejected and remanded that they go for fresh tender. And identical issue, Lordship, 8 matters last week disposed of. He remanded the authority to reconsider after providing opportunity. If Lordship permit, I will place that order. Lordship.
Grant some time to file affidavit. In this case, I filed affidavit. In this case, I have not filed affidavit. Grant some time so that
69 and 69.
69 has two
Sub-item, my lord.
Sub-item.
Sub-item, my lords. That is WPC number
42071.
Yeah, Lord.
Smile.
And what about 40841? Who is appearing in that case?
This is the one, my lord.
Oh, same thing.
Same
matter.
Different.
Same tender.
No, Lord.
Not same letter.
Then why these matters were tagged?
It related to, since it is a cancellation of tender, so it has been tagged.
No, it should not be heard together.
My
lord.
How much time will you take?
2 weeks, man.
No, there is no retender, my lord. This one line is the go retender, my lord. I have ready to there is a negotiation card, and this tender, my lord, the works tender, there is a OPWD code which provides a mechanism for finalization procedure of tender that stipulates normally lowest evaluated selected bid should be accepted. Where the tender authority accepted in twice negotiation, the rate is 0.50 less from the estimated, and one line the higher authority said. Cancel and retender, my lord. I only enter, my lord, saying they not to retender, my lord. Then otherwise it will be infrastructure.
There are direct decisions on this point.
Your lordship, if these, your lordship, I have, your lordship, but here is a case of because I am not, my lord, suitable to them, they can't, my lord. I am on the arbitrary, my lord.
They can do something which may look arbitrary. We don't know whether.
Short date, my lord, next week, otherwise. So otherwise, what is the counters comes, my lord? I only.
Next time it allows for the estate to file counter affidavit. Let this case on 4 weeks. This time in the meanwhile may be utilized by learned counsel for the petitioner to file rejoinder if so required.
In the meantime, if any retender is invited, I may be permitted to leave to this move this, my lord. That's some observation, my lord. Because I am
You will be
permit to move the interim application for move.
otherwise.
My lord, otherwise it will be infructuous, my lord.
Otherwise.
Otherwise it will be infructuous, my lord.
Otherwise you are stopped.
Infructuous, my lord. That observation, little observation, I nothing.
It's not required. Mr. Counsel, you file, make a
Some, my lord, because your lordship on 22nd December 2023, as you please to issue notice.
unnecessary observations.
Liberty
is there always. Why do you seek liberty which you already have?
Your lordship has the last issue notice.
We grant liberty when if such liberty is not granted, that may prejudice your case.
Your lordship, please. December.
While disposing of matters, we grant such liberty because if we don't grant liberty, then you may not have a case. Therefore,
Your lordship, short date, my lord.
Let us 2 weeks.
Yes, sir. 2 weeks, maybe. After 2 weeks, maybe fix your lordship.
All right, 2 weeks.
Obliged.
So improve your affidavit for.
Yes, my lord, we have your lordship. From the date of instruction, I have circulated all my clients to do this. I have already done.
This case also.
It's already done, your lordship. I will file in the register.
All right.
Obliged.
Item 70.
Item number 70, we have complied the order. We have issued an order of appointment in favor of the Lord's present petitioner, saying that it shall abide by the result of the.
There is no representation on behalf of the petitioner. The counsel representing the estate has submitted that this court's order, violation of which has been alleged in the present contempt application, has been fully implemented. So, considering the fact that there is no representation on behalf of the petitioner and the submission advanced on behalf of the estate that the order has been complied with, the present proceeding stands dropped.
71. Plus, may I hand over the copy of the employee engagement order?
Yes. Give him a minute. Take that on record. For record,
71, 72, 73. All three are that non-compliance of the order passed by the Assembly Court, madam.
71.
Here there was the direction to the OP number 2 to comply your lordship's order, Lords. But now, Lords, I have obtained instruction, your lordship were pleased to issue notice. Now, I received a reply from that Lords contempt number 2. He says that in the year 2021, he was working there as Lords, the officer in charge. Now he has been transferred to somewhere. My friend, I think, has to impede the present incumbent because in 23 he has filed this Lords contempt application. Or else, if you
so according to you, if violation is committed by A,
no, I don't say that.
He should be punished because he has subsequently joined.
No, I don't say that. If a lordship please to grant me some time so that I can also obtain instruction.
This is a quasi-criminal proceeding.
Yes.
And one who violates the order,
he has to be
punished. Yeah. Not the person who is holding the post.
Right, Lord. Lordship grant me some time. In the meantime, I will obtain instruction this stage of this Lordship.
Get it implemented, otherwise we will not punish only one person.
Right, Lordship.
We shall punish every person who was holding the post.
Right.
When yes, all of them.
Lordship 6 weeks time, your Lordship grant me. In the meantime, we see that.
As requested on behalf of the contemners. So as to ensure that this court's order is fully complied with. The matter is, list this matter on 6 weeks. 8 weeks, 2 months. We are giving you 2 months time.
Right, Lord.
To see that the order passed by this court is to be complied with. To see that the order passed by this court is to be fully complied with. Yes.
Fully.
Because the petitioners are land housed. The land was taken over by the project authority for the purpose.
All right.
Yes. All the three are same. 71, 72, 73, madam.
71, 72,
73.
Separate orders.
Yes.
Item 74.
But in item 74, I filed an affidavit not on 24th of January, stating therein that the order which has been they want to implement that has been appealed by the state in land acquisition appeal number 41 by 2023. So, in view of that, I await compliance of the order because the award which has been passed by the land acquisition authority has been appealed by the state. So, I've given that appeal memo also annexed A by 1 to my so-called affidavit.
So you have. Please come again. I just missed to notice your submissions.
Yes, sir. Against the award passed by in the land acquisition proceeding, the state authorities have preferred an appeal before this honorable court, which is the competent court, in appeal. That appeal has been numbered as land acquisition appeal number 41 of 2023, which is pending disposal. That I have given to Lordships. So because of this pendency, Lordship may not be able to comply with Lordship order, because once we comply, this appeal becomes infructuous.
What is the order?
Order is to make payment so far as the compensation amount is concerned. If I bring your Lordship to the...
Write in information.
My lords, humbly pray for short time to get a reply for that submission, my lords. A few week times to reply the affidavit, so of course he filed by the Fantimna 1.
No, but his submission is that the order cannot be complied with unless that matter is decided finally. What is wrong in his submission? And we punish under the Contempt of Courts Act. Only we are satisfied that the violation is willful. So it cannot be said that the order has not been carried out willfully.
Short time. my
There
lords,
is something, all right, as requested on behalf of the petitioner, so as to enable him to consider the so-called which has been filed on behalf of the contemners. Let's this matter on 4 weeks.
75.
Oh, wait, no.
75, your lordships would just permit me to apprise the urgency of the matter. Your lordships, this deals with admissions of BSc nursing in our state of Odisha. Earlier, your lordships, and still today, 15% of the seats in private colleges are for management. And that 85% seat, if the government cannot fill up, also goes to the management. Earlier, what used to happen is, your lordships, we used to fill it at our own level. And we need not take it from the general counseling, because obviously general counseling has not given us the students. So that's the reason. This time the nursing INC introduced that no, everybody has to sit for that common entrance test and you'll have to take students from there. But strangely, it has issued notices saying, no, the percentage now is 0. So literally the exam becomes meaningless, but they are still insisting that you should sit for the exam. And this has come all suddenly, because of which now we have almost more than 12,000 seats vacant on all over Odisha in all the private institutions. So, your lordships, what has happened is we don't have the counters now here. And the last date for filling up the management seats is also coming to an end. Your lordships, end of this month itself. as such, we are delayed this year. We are thoroughly delayed. We've crossed over to 24, whereas this should have been completed in 23. So in that view of the matter, your lordships, in fact, today, before your lordships board, there are 3 matters. The other 3 matters are not there. In fact, one of the matters is a lead matter in which the DMET, which controls the counselling in state of Odisha, is filing a counter. But your lordships, our insistence that INC takes a lot of time to file the counter. But we have brought on record how INC has made the percentage 0. So literally, whether you sit for the exam or don't sit for the exam it's the same thing. So your lordships will comply with all the affidavits, supplement affidavits, and this counter. But meanwhile, if your lordships indulges us to ask the INC to file an urgent, because it's union, it takes little time in our state.
I am appealing for the INC, my lord, Indian Nursing Council, and the one copy I received out 42785/2023. Other 2 represent. So let them serve the copy. We'll try to best to file it as quick as possible, man.
Mr. Padi has received it in my application.
Other 2 cases, first or third? First and third.
I don't know. I have received the for INC for 42785/2023. First time come immediately, I will accept the instruction, and if my
who is appearing in the other 2 cases?
Other 2 cases, your lordship, I am appearing, your lordship.
Both the cases?
My lord.
Have you served copies on it?
No, I didn't
If
receive.
not served, I will serve the copy.
If not served?
Because my file shows that it has been stopped. My phone.
Indian Nursing also.
Yes, yes.
Then you.
In fact, the facts must be common in all the 3 cases.
All common.
In fact, the lead matter today is not there before your lordships. That was served, I think, somewhere in 17/1/2024.
Case is decided,
lordships.
that will serve the purpose.
Absolutely, absolutely.
So 4 other matters are there. In one matter, we have filed our counter for the state, my lord.
All right. How much time will you take? Have you filed counter affidavit?
A copy of
We
the
have not
counter.
filed just now. We have received the copy the first time it has come. So let's say we allow 3 weeks time, we'll file it.
That may not be the case. The lead matter is WPC 39868 of 2023. Today it's not there on the board. There also we have served a copy, and there the orders were on 17/1/2024. I think if Mr. Pari checks up his office, he'll surely get that.
Number, but where is that case?
That has not come today. So we are forwarding, we've given all the list.
When was that case last?
17/1/2024.
I'll check it up, man. Please. The number I've noted.
We will take up the matter tomorrow again because of the urgency.
Yes, my lord. Yes.
All right.
My on Thursday, my lord.
Just a minute. And we will fix a date
Sure.
for final hearing, particularly because it relates to academic session and education.
Right.
So tomorrow we will be fixing a date for final adjudication of the entire matter. So you will be required to file your counter affidavit accordingly. So please tell your client that this is the circumstance in which the counter affidavit is to be filed.
We'll try to file as quick as possible. As quick
There's
as
no
possible.
question of yes.
As quick as
quickly
possible. Yes.
You can try.
Yes. I'll try to file as quick as possible. Definitely.
Tomorrow we will again take up your matter.
Right.
These matters.
And we have also handed over all the list of matters.
Right.
In the meanwhile, let them solve all the copies.
A little lordships were actually finding that amendment in that book.
Do that affidavit.
No, the amendment which your lordships were searching, that Odisha amendment. I just wanted to bring it to your lordships' notice, and I think Justice Sinha has already seen that. There's a problem here that a lot of new acts and rules, especially 309 rules, are coming up, which you will not get it in the domain at all, and it's very difficult to search. So if your lordships,
it can be done.
It's very difficult. Justice Sinha has seen that SC/ST rules, and because of his indulgence also, now it got published, and in fact, yesterday we got
every notification, statutory notification, every rule, amendment, everything will have to be notified. We will ensure that.
Lordships.
Obliged.
Yeah. All right. These cases will also be listed.
Pardon me, your lordships.
Just a minute. So, last one. This is over. Yes.
Pardon me, Your Lordship. Your Lordship, my learned friend made a mention in the morning about an admiralty suit. And my lord, I say it with a lot of responsibility, my lord. Your Lordship are the master of the roles, but being a local advocate, I just wanted to bring to your Lordship's notice. Now, my lord, the High Court rules says that any my lord, a suit coming before the court in exercise of its ordinary and extraordinary original civil jurisdiction is a single judge's matter, my lord. And also, my lord, we also checked up the Act. Admiralty Act says that against an order of a single judge under Admiralty appeal. So we just wanted to bring to your Lordship notice that it has to be for a single judge.
Thank you.
So if your Lordship can be
It's a pleasure to address my lords, whichever court, but my lords.
Thank you.
So we wanted to just bring it to your Lordship notice so that.
Thank you so much.
Grateful, my lord. Thank you.